National Virtual Summit on Competence to Stand Trial and Competence Restoration, presented by SAMHSA's Gain Center with the support of SAMHSA, which is the Substance Abuse and Mental Health Services Administration. Today, we are pleased to present 3 consecutive sessions focused on a review of the work, states' efforts to improve competence to stand trial and competence restoration processes. We begin today's summit with a keynote address by Dr. Deborah Peinels and Dr. Lisa Callahan on competence to stand trial and competence restoration, a national scan of key issues and ways to address them. I am Erica Ihara, and I am a project associate at Policy Research Associates and SAMHSA's Gain Center. Before we start the presentations, I have just a couple of housekeeping items to review. First, our disclaimer: the views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the Center for Mental Health Services, the Center for Substance Abuse Treatment, the Substance Abuse and Mental Health Services Administration, or the U.S. Department of Health and Human Services. If you have any questions for the presenters today, please use the Q&A pod, which is located on the right of your screen, and we will address as many of these questions as possible during the 2 discussion groups that are scheduled for later today. We will also be conducting a couple of polls, and we always appreciate your participation in these polls. You may have seen one just pop up on your screen now, and we will be sharing some of those results in just a few minutes if you'd like to enter your responses. This webinar is being recorded, and slides will be disseminated via the Gains listserv following the summit. We will also notify you when the session recordings are posted to SAMHSA's YouTube channel. And a certificate of attendance will be available for download at the end of each session. And just as a reminder, these certificates are for your portfolio use only, and they are not for CEU credits. We have American Sign Language interpretation for today's summit. And to view our interpreters, if you don't already see them on your screen, go to Layout in the upper right-hand corner of the screen, select Hide Non-Video Participants, and then change the layout view to full screen. Finally, select View All. And we have 2 interpreters for today, and their names are Michelle Johnson and Megan Thorpe. We have live captioning for this event. To view live captioning, select the Accept button in the Multimedia pod, which is in the lower right of your screen. The color contrast can be changed as needed, and we recommend high contrast style for best visibility. And next, I would like to introduce the agenda for our first session of the day. Roxanne Castaneda will give some comments from SAMHSA in just a few moments, and then the presentations from Dr. Lisa Callahan and Dr. Deborah Peinels will follow. And now I will turn this over to Roxanne Castaneda. She is Public Health Advisor and Task Lead for SAMHSA's Center for Mental Health Services and SAMHSA's Gain Center contract for some opening remarks. Welcome, Roxanne.
Good afternoon to everyone and welcome. In 2017, the Interdepartmental Serious Mental Illness Coordinating Committee, or ISMIC, was organized to address serious mental illness and severe emotional disturbance across federal departments and the systems they represent, like SAMHSA, the Justice Department, Department of Defense, Housing, Education, Labor, CMS, and Social Security Administration. One of the areas of focus was Focus 4, to increase the opportunities for diversion and improve care for people with serious mental illness and serious emotional disturbances involved in the criminal justice system. Focus 4.4 talked about establishing and incentivizing best practices for competency restoration that use community-based evaluation and services. In 2018, the SAMHSA Gains Center completed a review of literature and environmental scan to provide an overview of the current status of the field of competency to stand trial, incompetency findings, and restoration for adults. In 2019 to 2020, we established communities of practice with states that applied and were accepted to set goals, strategize on understanding the issues that concern their specific states, function in the areas of competency to stand trial and competency restoration. Today, you will hear from several experts who participated in the project, the challenges they faced, and the accomplishments they achieved. SAMHSA would like to take a moment to thank Dr. Lisa Callahan and Dr. Deborah Peinels, whose leadership and commitment to this project since 2017 has guaranteed its success, and to Sam Rogers for his invaluable assistance throughout the project. Lisa?
Thank you, Roxanne. And now it is my pleasure to introduce our two keynote speakers. Dr. Deborah Peinels is clinical professor of psychiatry at University of Michigan Medical School, where she is also the director of the program in psychiatry, law, and ethics. She is medical director of behavioral health and forensic programs for the Michigan Department of Health and Human Services, and senior consultant to Policy Research Associates and SAMHSA's Gain Center. Dr. Lisa Callahan is Senior Research Associate at Policy Research Associates and SAMHSA's Gain Center, and she has led the work at the Gain Center for the Competence to Stand Trial Learning Collaboratives over the last 3 years. Dr. Peinels and Dr. Callahan were both awarded the American Psychiatric Association's 2021 Manfred S. Guttmacher Award for their outstanding contribution to the literature of forensic psychiatry with their 2 recent articles on competence to stand trial. And I'd like to just share a few observations about who is in our audience today, if the results are ready. And unfortunately, I am unable to access the results. So if we can make that available later, we will, but for now, we will move on. So now please join me in welcoming Dr. Callahan and Dr. Peinels as they kick off today's summit with the keynote address. Thank you.
Great. Thank you so much, Erica. And thank you especially to Roxanne and to SAMHSA and to my good friend and colleague, Lisa, for helping put this together and allowing me to be part of this really important conversation. I am grateful to my state colleagues and to the federal partners that have been playing such a key role through this work and through SAMHSA's work trying to drive change in this space. I'm also grateful to see how many people are joining this webinar as we speak. It really is a sea change that I think we're embarking on here, to look at a very complex system that was set up with the best of intentions, and one that requires us to look with the lens of the year that we're sitting in now and the future, to try and right size a ship that has really in many ways gone astray, again, not through any one individual or entity's fault, but because of some of the shifts in overarching policies, practices, and other issues. So I am going to talk a little bit about that. And first I want to do some level setting and get us grounded in competence to stand trial itself. Because as I said, the importance of understanding where we're at really relies on us to understand how we got here. So first of all, competence to stand trial is a very critical right in our society. Our entire system of jurisprudence has many cases that rest on the idea that a defendant charged with a criminal matter must be competent in order to serve as a pretrial criminal defendant. It's grounded in 6th Amendment rights and 14th Amendment rights, that individuals with mental illness or developmental disabilities or any other condition that compromises their ability to stand trial should be examined and should be looked at very carefully. And the trial highway, as one of my judge friends says, should be stopped. And this person should be routed off the trial highway until something is done to ensure that justice is meted out fairly in our criminal system, so that we're not trying defendants who are not capable of serving as a defendant. And this is really the foundational principle that continues to be a foundational principle that we can't ignore as we're looking at some of the systemic issues that have arisen. So the next thing that we all have to understand is the basic steps that an individual person goes through before they are considered a defendant, and then also what happens once they are considered a defendant and their competence to stand trial is raised. So first of all, any defendant has to be arrested. You don't get into the criminal system without there being some question of some act that the individual committed. And then when they are in court, usually after arraignment, but sometimes even upon arraignment or when they're first noticed, there's this issue of their competence to stand trial. And the way the case law really delineates this is that this is such an important issue in American jurisprudence that the competence issue should be raised by any party. If there's any doubt that this defendant is competent to stand trial, the issue would get raised and the judge would order an evaluation, or there would be evaluations that would be sought by either defense or by prosecution. But most often what we see is the judge ordering an evaluation. And then within each jurisdiction, there's a stepwise process that occurs whereby there might be a certified examiner who does that initial competence to stand trial evaluation. And that is a whole, any step along this pathway raises a number of questions that you might be asking for your own jurisdictions because you may not have a certification system. So you may have a panel of examiners who are available to the judge at the local level, who the judge relies upon to conduct these evaluations. And then there might be, from that evaluation, other experts that make their own evaluations, and then there might be a contested or an uncontested hearing about that defendant's competence to stand trial. After the evaluation and during a hearing, there's going to be a finding by the judge of whether this defendant is actually competent to stand trial or not. If they're not considered competent to stand trial, there would be a finding of either them being incompetent but restorable or incompetent and unrestorable. Now, again, there's going to be jurisdictional variation. State laws will vary as to these kind of three main buckets that might that a defendant might then fall into as they travel down the trial highway. And again, some states, very few states don't have restoration in their statutes, but for the most part, there's going to be these elements. And most people actually who are evaluated will be found competent to stand trial. We know that from national data. Of the percentage of individuals for whom their competency is found to be sufficiently impaired that they're incompetent, most will be found restorable by the judge, and then some number will be found unrestorable. When a defendant is found incompetent and restorable, then there is a disposition that is made where the defendant will be ordered for treatment for restoration purposes. If a defendant is found unrestorable, there is the possibility, again, depending on the pathway within one's own state, if the defendant meets the criteria for a civil commitment, which is not the same as meeting criteria for being unrestorable, this defendant might be eligible for a civil commitment or might be required to undergo a civil commitment, depending on the frame of reference that you use. And they would go down a civil route from that point of view. Otherwise, a defendant who's ordered for treatment for restoration would undergo a period of restoration, again, defined often in state law for how long that period of restoration would be, and it might depend on the charges. And then following that period of restoration, that defendant might be, again, found unrestorable. They might be subject to a commitment. They might have charges dismissed. Any number of things could happen, or a new order might be issued in some states where you have another chance of restoration from that point forward. So these are complex pathways. And what we've seen across the United States is that there are many things that are system dynamics. If you like to think about hydraulics and complexity of systems, there are many variables. Historically speaking, all incompetent to stand trial defendants who were ordered for restoration would go to the state hospitals. And as Roxanne said, there's very much going on from ISMIC and beyond, trying to look at how do we move from a Americans with Disabilities Act perspective and other types of perspectives into community-based settings when that is the appropriate and safe things to do. But within the hospitals and within these populations, we see lots of variables that play a role in these system dynamics. For example, the shifting populations of those individuals found incompetent to stand trial, many of whom have co-occurring conditions, including substance use disorders, staffing limitations now across the board in various settings, shifting dynamics of evaluation practices, as well as restoration practices that can play a role in efficiencies and outcomes. What I call external variables, including the variables of what brings people into the competency system to begin with. First of all, as I said from the beginning, I'm a real believer that everyone has been in this with the right intentions, playing their role in the process the way that they are best know. And so many people have looked at the competency restoration system as a way to, quote, get people help, because they're identified as having significant cognitive impairments due to a variety of conditions. And people think of restoration, it's such a positive word, of who wouldn't want to be restored in that framework. There also may not be sufficient community-based alternatives that would allow for people to be restored in alternative settings, leaving the hospitals to be that default setting, or in some cases now even jails, and there's lots to talk about with that. There's also evolving standards of legal best interests in the sense that, of course, because this is such an important right grounded in constitutional principles, you want your defendant to be competent to stand trial, but now we're learning a lot more about jail diversion, and that for lower level crimes, it might be that the legal best interest for this individual might be that they engage in a pretrial diversion program as opposed to moving through the forensic competency system. There may just be a lack of awareness of what this is all about, and that's why it's so exciting to see so many people joining this national conversation. Also, there's external variables about conditions of confinement. In other words, there may not be sufficient care and treatment in the setting in which a defendant is placed, leaving them at risk for having further competency challenges because they're not getting the medications they need or the environment is so disruptive to their stability. And furthermore, the external variables are that as people move, as I've referred to it in some of my writings, as the crossover population moves from the community to jails to state hospitals, across multiple settings to emergency rooms, unlike somebody with diabetes who may need insulin wherever they go, people with serious mental illness often have disrupted episodes of treatment, which creates further problems for them to regain their stability. So what does it mean when an evaluation takes place of somebody's competence to stand trial? Well, we generally think about four major domains that we're looking at. We're looking at whether this individual understands the charges that they are facing, whether they understand the potential verdicts that they may be getting, and the potential consequences of those verdicts, ranging from release, probation, to jail, or even a prison sentence. We also are examining whether this defendant understands who the trial participants are and what the trial process involves. In other words, do they know the role of the judge, the defense attorney, the prosecution? Do they understand how the process works? In other words, that they have a right to testify or not testify, that there might be a jury trial or a bench trial, and how the prosecution mounts evidence against them, and that they are essentially the person that is on trial for a criminal matter. The other thing we look at is their ability to assist counsel. How is this defendant working with their defense attorney? Now, some defendants will not want to use a defense attorney and will want to represent themselves. And that brings up a whole nother set of legal and clinical issues. But we're looking at whether this defendant is able to assist their counsel. Are they so impaired in their behavioral regulation that they can't sit still, that they may be shouting or aggressive or speaking irrational things and not able to convey to their lawyer kind of what they're thinking or help themselves in terms of their defense and looking at what happened at the time that they were arrested. And then finally, one of the most difficult parts of the assessment, and frankly, I think one of the most difficult parts for decision makers and judges and everyone to really wrap their heads around, is this whole decision-making ability of the defendant. All humans who are competent in certain domains are eligible to make their own decisions, even if the person evaluating them may not agree that it's a good decision. But the question is this person compromised in their ability to make decisions in their own defense? So in other words, if an individual has a delusional belief that the judge is involved in a conspiracy against them because of signals coming from the sky and Martians in some what might be considered a bizarre delusional system, then they may not feel that they can make a decision about a bench trial versus a jury trial. They may feel like they're making a decision that's in their best interest, but the evaluator would be looking at that issue and saying that their decision making is compromised by delusional thinking and therefore may not be competent. Even if they understand their charges, even if they understand the verdicts and potential consequences, they can understand all sorts of elements that are involved in competence to stand trial, but their decision making may be compromised. The other thing that's important to realize is that we're not just looking at factual understanding, we're also looking at that defendant's rational understanding when we're doing these evaluations. And that can be another area that can be difficult to parse out when we're doing these assessments. So the assessment itself is a complex assessment, but it is entirely focused on this individual's abilities relevant to being a defendant. It is not an evaluation of this person's abilities relevant to making treatment decisions or understanding their mental illness so that they can make the best treatment decisions for themselves in terms of medications and therapies. It's a very different type of competency that we're examining when we do the forensic evaluation of competence to stand trial. And that's very clearly spelled out in the statutes in which we work. Now, for a defendant found incompetent to stand trial who is ordered for restoration treatment, again, a whole host of other things can happen. And one of the things that I want to convey to you is some of the current waves that we are seeing. So this is data, and I'm very grateful for the Nashville Research Institute for pulling together some data that really looks at the utilization of system structures for this population. And what we have seen, if you look at this, the average one-day census of state adult forensic patients at state hospitals, essentially what we're seeing across the United States is that state hospitals are becoming more and more filled with forensic populations. Now, one could argue, well, that's because the state hospitals closed and the civil, the doors and shut, fewer numbers. And that in part does explain some of it, but it doesn't fully explain what's going on with the census. But what it does tell you is that in systems where you have one hospital that maybe 50 years ago was designated as the forensic hospital for the state, now what we're seeing is in the regional hospitals across the United States, the regional hospitals have people that are involved in the forensic system or who have histories of forensic involvement. And so what that has meant for the state hospitals is that they have had to shift in their clinical approaches. And I remember working in a state hospital when this was it felt like people were really not comfortable in this space of working with forensic populations. But now more and more state hospitals are getting comfortable because that is who they are serving. And what we're seeing as we move into the community, some of the community systems are learning the same thing. Now, of course, we're going to get to why we don't want to always be in the world where we're serving forensic people as a primary population, and we really want to have civil systems become our forensic prevention strategy. But we are really in this right now, and so we're seeing systems shift. The other thing is that we're seeing wait lists. And this is data that's somewhat old right now. And many states have worked to tackle their wait lists, which is really exciting. But there are wait lists for people to get into state hospital beds. And frankly, if you look at anybody on the wait list, not everybody on those wait lists needs to get into a state hospital bed from a clinical perspective. But because they have been determined to be incompetent to stand trial and have been ordered to a place for restoration, and that place, the default place has traditionally been the inpatient state hospital, they are nonetheless on that wait list. Now, this is a slide that's a little bit hard to read. It comes from that same study, but if you just look to the right at the average, I think that's the most important. And this goes back to looking at who are these forensic patients in these state hospitals. This slide shows us that overall, across the United States, we have seen an over 50 or maybe even 60% shift over time in terms of the percentage of people found incompetent to stand trial in the state hospital beds. So when we talk about the forensic population, the highest growth population, actually the insanity defense population, which is another forensic population, has been relatively stable. That's a whole nother conversation. But the highest growth rate of populations that we're seeing are the inpatient, incompetent to stand trial population sent in for restoration services. Now, this has raised other challenges, and by last count, at least 14 states, I think there's more at this point, were or are involved in litigation over these wait lists for restorations. And again, there's complex factors that affect wait lists. One is state laws, how the state laws actually delineate the flow of humanity from arrest to competency to restoration to release. Lots of issues come into play in terms of how state laws are written. Courtroom personnel, again, trying to do their best to get people into help, but perhaps not realizing that the restoration goal itself is not a general treatment goal. The restoration goal is to help this individual return to the trial highway as a competent pretrial criminal defendant. So when we look at the functional impairments involved in the individual that renders them incompetent to stand trial, what restoration does is really help that person with those specific functional impairments so that they can get to face their criminal charges. And one would say, well, is that the best way to utilize resources? You know, we don't want individuals with mental illness or intellectual and developmental disabilities to have open charges hanging over their head without some resolution forever and ever and ever. That's another challenge that we have to deal with. But again, just keep in mind that this restoration goal is really something that judges, prosecutors, defenders, treatment providers may not fully realize what it's about. The treatment resources and common practices are also these complex factors that can affect these wait lists. So we have taken an opportunity to really do some deep dive system examination and develop creative solutions as we look at this. If this was one of the original maps that I've shown this map for years, sort of a generic look at how this individual might move through the system. And I used to refer to it a bit as a chutes and ladders type of analogy, although it's not a fun game for the individuals that are subject to all of this, because what's happening is they may be moved, they may be found incompetent to stand trial. They might be ordered for restoration services. They might have to wait for those services. When they get into those services, they may get treatment where they are restored. Then once they're restored, because they're restored so that they can go back to the trial highway and be a pretrial defendant, unfortunately, they may go to another setting where they decompensate. They may be off their medications. They may not have access to that treatment. And then they start all over again because they appear back in court. They look again, psychotic or manic or whatever the issues were to begin with, and then they're sent back for another period of restoration. And moreover, we know that people, even once they're released, are more likely to be back in the system. And so what we see is people returning over and over and over again to the competency system. And this is why we're having this talk today, to try and help people understand the innovations that are happening across the country, to try and move from this cyclical pattern to really think about alternative strategies for these individuals that will not compromise public safety. That is not what we're trying to do, is compromise public safety. We're trying to be smarter about resources and about what we know about the reasons people are found incompetent to stand trial. And so there's been a lot of kind of quick fixes over years that people have thought about. For example, states that have rapid access to evaluators through appropriate fees or court-based evaluation structure. My former state of Massachusetts, where that I'm still very attached to, where we had court clinics available to every superior district and juvenile court in the Commonwealth that could do same-day evaluations. You have other states where you can work, where they've worked on transfer to inpatient settings prior to competency proceedings. There's competence courts that I think you're going to hear a little bit about today. IST dockets, where you have judges that are really devoted to this population and really aware of the system's issues and working to address them more out of the front end of the work as opposed to the back end. And then time-sensitive case processing. There's a whole thing about time standards. The time clock on, right to a speedy trial gets put on hold while a defendant's competency is being addressed. And so that can lead to people languishing without anybody paying attention to that clock. There's also been efforts, one of the things we've been doing really in Michigan is looking at utilization management of all beds within the state hospital in a way. And when I worked in the Ohio system, we were really big on that for the competence to stand trial population, to really move people through and not have them languish in places they don't need. And what we really want to do is get the right people at the right level of care at the right time. And so not everybody needs a hospital bed for a long period of time. We can really keep those resources available for people who need it by doing tighter utilization management, looking at standardized approaches to restoration. What restoration actually means, what it entails, can vary from jurisdiction to jurisdiction. Also state laws looking at reasonable statutory timeframes for restoration. At what point do we say this person is not going to be restorable and we move them into another alternative route? And then, of course, these community-based strategies, which might include work within the jails and certainly a lot of work outside of the jails. Mechanisms for information sharing. Of course, these early quick fixes, video conferencing, sort of interesting now to think about now that we've all moved to video conferencing with the pandemic. But those were identified as strategies that people could utilize as a way to kind of keep the system flowing. And so these return to court stage quick fixes involve coordination, communication, transportation, discharge planning that involves potentially aftercare. We see forensic navigators popping up from jurisdiction to jurisdiction. And also really looking at who is in this competency system. If really what we're looking at is the individual's ability to serve as a pretrial defendant, well, people charged with minor crimes, if you track them through the system, and we see this with poverty, the intersectionality of poverty and serious mental illness, where people will be arrested on minor crimes. When they get to the end of this competency pathway, really the prosecution is really not interested in pursuing these charges to begin with. And so why did we send them through this pathway? Was this really the best pathway to keep them from being rearrested in the future? And so, the ABA has even taken some positions recommending that, if you're the defense attorney, it may be that you don't need to call the competency question, but what you might want to think about is working with a local diversion program to have this particular defendant moved out of the criminal legal system altogether. So in doing this and thinking about all these issues, it's really important that we've been thinking about forecasting challenges and opportunities. We have seen a tremendous amount of change, even since 2017, since we started this. And I'm not just talking about the huge change that we've all experienced through the pandemic. That, of course, has led to unprecedented system changes at every level of every system and internally within ourselves. But even separate from that, prior to the pandemic and since that time, many states have divided their state hospital administrations and their community mental health systems into different administrations. There have been different partnerships evolving with Medicaid in different states. The community behavioral health system has evolved. We have certified community behavioral health clinics popping up through the SAMHSA demonstrations and through CMS. And so the structures and functions that fund the services and direct the services from a policy level are evolving. And this is why we are in such an opportunity for sea change, to really think about how do we write the system so we don't have people with serious mental illness and intellectual and developmental disabilities and traumatic brain injury languishing, waiting at every step of the competency process for the next service to come up, when we know that the requests for evaluations are only going up, and therefore more and more people are being found incompetent, being funneled into the system. Now is the time again to rewrite that ship. We have video evaluations, downsized jail populations with COVID-19, some concerns that people in the competency system are some of the ones that are silting up, like we saw, like people were concerned about with state hospitals, who's left in the state hospital. Maybe now we worry that we're going to have people with serious mental illness more likely to be left in the jails because of the complexity in the disposition that we need to address. And how do we think about those connections to community services more now than ever? And so care coordination, case management, treatment and support and linkages is really on the tips of everybody's tongue in terms of how we think about these populations, both at the evaluation stage and maybe even avoiding evaluations altogether, because we can divert people out of the system, out of the forensic system, or at that restoration stage for those that move through it. This requires multiple parties that people perhaps didn't think about. We often think about the mental health system as the key driver for all of this. But when you really start to look at who's now in the competency system, and it is who was in it before, but we can actually drill down with even a finer grain, looking at how do we bring in not just state hospital leadership, forensic leadership, community behavioral health leadership, but what about aging and older adult services? We have a small but significant and growing population of older adults who are in the competency system with neurocognitive conditions. We have individuals who've got histories of military service that we want to make sure are connected to veteran services. We've got a small but significant population of individuals with intellectual and developmental disabilities. It's actually the second most common reason, besides serious mental illness, for being found incompetent to stand trial. People with Medicaid services who might have certain opportunities under Medicaid, and then housing and homelessness services that need to be looped into these conversations. Then besides the executive branch authorities, we've got the judicial partners at the table. We've got the National Judicial Task Force looking at improving practices for individuals with serious mental illness in the judicial system. They're paying attention. Legal authorities, disability rights advocates, persons with lived experience saying, hey, we want to be part of this conversation, and they should be. Legislative branch partners, correctional systems, county executives. So we've got a whole host of problem-solving partners that we can bring to the table. And again, I'm grateful for Dr. Callahan and the folks at PRA for helping to develop this graphic, because you're familiar probably with the sequential intercept model. What we have tried to do is drive this conversation into that focused area. If you notice at the top, we show this at the intercept 2-3 space, because we're really talking about that pretrial space all the way to release from jail. And that if we can look at this and really look, and I got to work one of these years with North Carolina, for example, that did a very concrete mapping of their competency system, from evaluation to orders to restoration to release, to look at how do we think about building in diversionary strategies. So if you think about it, people in the competency system that are found incompetent to stand trial are really some of the most impaired people from a cognitive perspective. But because of their limits, they are often the least eligible for diversion programs because they get routed through this forensic system. So just intuitively, that makes no sense. We should be finding ways to support their ability to be routed out of the competency system and eligible for diversion programs, perhaps unique ones. And so we drew this pictorial diagram to help delineate these issues. So we have a lot of multi-systemic challenges. We have to come together around this to look at the needs, develop plans, and buy-in for better case pathways for these individuals. And then to think about the disposition of these incompetent defendants. There is one case that I like to talk about, and that is the Jackson versus Indiana case in 1972, in which Theon Jackson, who had an intellectual or developmental disability, was also deaf and mute, was charged with 2 robberies for $9 total. He was found incompetent to stand trial and committed to the Indiana Department of Mental Health until sane, which meant until restored to competence. Well, his lawyer argued he will never be restored after clinicians said we can't restore him or remediate him, as the case may be. And that is cruel and unusual. And it's a due process and equal protection argument because it was so technically easy for him to get in the system, but so impossible for him to get out of the system that it was a constitutional violation. And in fact, the US Supreme Court ruled in favor of Jackson, saying due process requires that the nature and duration of confinement bear some reasonable relation to the purpose for which the individual is confined, and that the length of commitment must not exceed the time required to see if there is a substantial probability that the defendant is restorable in the foreseeable future. And if restoration is not possible, commitment, if necessary, must be through a civil route, not a criminal route. And I think that case holds true just as much today as we look at how people are stuck in these systems, and we are really working hard to help them so that it's not so easy to get in and so impossible to get out. And we need to work together around that as we are through this. And legal challenges are part of this mix that have helped drive this conversation, but so are all of you stakeholders interested in looking at this sequential intercept model as a framework that we use to think about these alternative strategies. So thinking about alternative sites to state hospitals, outpatient community-based activities, in some cases jail-based restoration, although I think we'll hear a lot about some of the challenges with that, and really trying to move people into the best settings. Also paying attention to different populations who are going to have different needs. Attainment of competence to stand trial is going to look different for somebody with an intellectual and developmental disability than somebody with a serious mental illness. How can we leverage the crisis system that's really hot right now and evolving? How can we leverage first court appearances, jail stays, and specialty courts? And you will get copies of these slides to be able to read these more in detail. And how do we look at jails and the role of jails and reentry services from jails and linkages to aftercare and coordination so that people stop rebounding back into this system? And so with that, I'm going to stop and turn this over to Dr. Callahan.
Thank you, Dr. Pindles, for that overview and elaboration on a lot of what the major issues are within this competence to stand trial and competence restoration space that, crosses over a number of systems. And that's one of the reasons why it is so complex. I wanted to give just a little bit of background before I talk about the communities of practice, that when we were approached by SAMHSA back in 2018 to do the national scan, what they and we had in mind was that we would be able to identify best practices, and a number of the questions that came in during registration that many of you put on your registration form had to do with best practices. And one of the outcomes of that is that there really weren't any national best practices. There really were no national standards. And so when we sought to develop this community of practice in the first year, it really underscored to us the importance of working primarily with state teams, but then also the ways in which the policies and practices and resources stemming from the state system made their way down to the local system, where the defendants and the local legal systems are actually doing the work in terms of, as Dr. Pindles referred to it, as the trial highway. So when we started this community of practice, these were our 4 objectives: to enhance the collective knowledge of key issues and familiarity with the topic. As I mentioned, we initially thought we would be able to identify some national standards, but we did not, and we're not. And we're hoping that the work, and one of our goals is the work that the states are doing collectively can really build some momentum in that direction. To understand promising best and evidence-based practices, to develop strategic plans that focus on this issue, and then to increase knowledge about the challenges and lessons learned in implementing these strategies through peer-to-peer sharing. And not only peer-to-peer sharing among the members of the community of practice, but also as we're doing today, in pushing that information out nationally. So states that are considering changes or have been maybe hit some barriers to the changes that they would like to enact can learn how these states that participate in the community practice were able to do that. So I mentioned, and as did Roxanne, the national scan of competence to stand trial issues. We also then, in the first year of the community of practice, we had a competitive RFP sent out for states to propose to participate in the community of practice, and we selected 8 states from those applicants, and they were Nebraska, Florida, Texas, Washington, D.C., California, Georgia, New York, and Illinois. So the first year of the community practice was with these 8 states. And I'll talk shortly about what some of the major takeaways were from that. In the following year, SAMHSA also fortunately supported our continuing the community of practice. And we had 5 states continue from that first year. And we had 4 new states that were among the applicants for the second year who were selected to be in the community of practice. And those new 4 states were Oregon, Utah, New Hampshire, and North Carolina. And then during the following year, we also had the support to do another year of community of practice on these issues, but we did not have a competitive RFP because we already had 9 states that we were working with. But we did add Alabama to our community of practice. They reached out to us independently about some work that they were doing in this area, and so we added them to the community of practice. So over the course of those 3 years, we have engaged 13 different states in the community of practice. We are going to have the community of practice now for a 4th year, and and working with the pre-existing states because the topics are a little bit more focused and an outgrowth of the work that they've been doing. So the national scan that we did in 2018, the biggest takeaway and the biggest takeaway across the board was that there really were very few empirical data and very little research in this area. Now that's changing somewhat, but there was no national research being done. There was research being done that Dr. Pinels talked about, looking at forensic beds, et cetera, but not really looking at the process questions. There was one of the takeaways as well was the need for cross-system collaboration, which Dr. Pinels referred to. There seemed to be a lot of interest across the states that applied, and across the national scan that we did is a desire for a least restrictive alternative, not just for competence restoration, but also for competence evaluation. As we have noted, all these slides will be available, so we will make sure that you get them if you're interested. The first year then of the community of practice, the cross-site priorities were, probably to no one's surprise, the number 1 priority was to reduce the wait times at every step of the competence process. One of the reasons that Dr. Pinels and I developed that 2-3 intercept flowchart was to look at and identify every point at which someone who is involved in this process could really hit a barrier in terms of not moving forward and adding to the, let's say, for example, the days they're in jail, the days they're in the hospital, the days they're waiting for an evaluation or for restoration services. And actually those questions or that priority are also reflected in many of the questions that we got prior to this summit today. Again, focusing on cross-systems collaboration, making sure that there's training and monitoring in the area of best practices. The 2 areas in particular were around the area of evaluation and also on restoration, and those will both be addressed today the work that some of the states have done. Looking for alternatives to hospital-based restoration, we found that even though many states had on their statutory books that they were allowed to have, say, community-based restoration, most states were not really having very robust programs, and that is something that many of the states worked on developing during the community of practice. And the other takeaway, and this links certainly to the first, is that there needs to be really a more focused effort put into collecting data really across the entire competence system if we want to have data-driven answers. During the Learning Collaborative, and just as a reminder, this was prior to the pandemic, so much of this work we did was in person. We provided intensive technical assistance to all of the sites. Each of the sites, the states also engaged in a 2-day facilitated strategic planning event, and then we had a virtual closing event. During this second year of the community of practice, wait, something happened here. Okay, there we go. So these were the accomplishments during that first year of the community of practice. You're going to be hearing about a number of these today, so I'm not going to go over each of them, but I think it's quite impressive if you see these are, in some cases, more than one state were able to make these same accomplishments. So one of the probably major milestones that was really impressive to us was that one of the states actually was able to introduce and have legislation passed to change the way in which their competence restoration was permitted to be in the community rather than just in the state hospital. I think all of us know being able to change legislation is really a heavy lift, and we'll be hearing from Nebraska a little bit later. The second year of the community of practice, we were fortunate again for SAMHSA support, but this was really in March of 2020. We all know that's when the pandemic hit, and so all of the planning and all of the work that we had done in the first year that we had intended to replicate in the second year was immediately put on hold because everything had to be switched to virtual delivery of virtual workshops, technical assistance, and the strategic planning. We bit off a lot, and I hope we were able to accomplish that. I think that we did quite, with the massive help from national experts. We were able to have 34 technical assistance, virtual technical assistance events that were led by our national experts. And the topics ranged are listed here. And we had 32 hour-long topical virtual workshops that were also led by national experts, and their names are listed here. This was a bit of a surprise to this, and I just as an aside is when we do in-person work, which I think all of us enjoy doing, there's a limited number of people who can participate in that workshop, for example, because of limitations of travel expenses, et cetera. And one of the observations that we had, an unintended consequence, I suppose, of moving everything into the virtual world, is that there was a very large number of people across all of the state teams who were able to participate in these workshops who previously probably would not have been able to attend an in-person meeting, especially people who are working in the various corners of some of these very large states. So the level of participation in these workshops and the technical assistance was really quite astounding and quite impressive. And then we had 6 virtual planning events that were facilitated by Gaines consultants and national experts. I want to just make a note here that I was making a list of all of the national experts who aided in this and really gave great insights and expertise to this community of practice. And it really is a who's who on who knows what anyone knows about competence to stand trial. Some of the names are listed here, as you can see, who led some of these virtual workshops, but a really big shout out to the people who lent their expertise to, not just to the community of practice wide, but did a number of the TA events for us as well. I think I counted around 25 to 30 national experts who've been engaged with us across the years. These were the accomplishments from 2020. And just as a reminder, we added 4 new states in that year. You're going to be hearing about some of those accomplishments today as well. And then for a third year, we convened the community of practice. I think in the back of our minds, we thought it might be a hybrid model of virtual and in person, but alas, it was entirely virtual. We added Alabama to the community of practice for this third year. And we had a virtual convening gathering the states to talk about where they've been and what their goals are for the community of practice. And also we build on our use of the sequential intercept model as a way of helping the communities plan for and identify what gaps and opportunities and plan for the changes they wanted to make. And so I'm going to be talking a little bit more about that in just a second. We had a webinar series for this year's community of practice. 2 of the webinars were what we called national webinars, in that they were, the national audience was selected, and that was the first 2 listed here on risk assessment and management in the context of competence restoration and COVID in the San Luis Obispo County, California criminal legal system. We also then had 2 webinars that were specific to the members of the community of practice. We again had intensive virtual technical assistance. And we also had, and these are the topics, and then we also had a virtual closing event in which each of the states talked about what they had accomplished, not just in this year's community of practice, but other years, building upon the years prior to this. I think, as many of you in the audience probably know, this is typically not a 1-year activity in trying to, or effort in trying to make improvements to the competence system. There are so many systems that have to be engaged, and so many legal and behavioral health experts who need to have input, that it often takes, the changes really need to be planned for a multi-year strategic plan, and that's what we did during this third year. These are some of the accomplishments that we were able to note of this year's community of practice. And one of the topics that we had technical assistance delivered on, and this is something I think all of you are probably experiencing, is a lot of staff burnout among the forensic providers. It's hard work in the best of times, and it's especially hard work in some of the most challenging of times, which the last couple of years have been. Dr. Pinos referred to the observation that there seems that perhaps people who are in the competence process are among the last people who have been either released on bail or have been released from jail. And so we heard from many communities that their jail population was increasingly being represented by people awaiting competence evaluations, or who were waiting a bed for competence restoration, or had been returned to jail waiting for their disposition. And as many of you on here know, and it was actually one of the questions that came forward, is the challenge of when someone has been restored, and has been returned to their local jail to await their disposition, they sometimes, without particular efforts on the part of the community, run the risk of decompensating again before they're able to have their case disposition. So one of the new technical assistance events that we did this year was we did this competence-focused SIM mapping with the state of Alabama. And while we focus specifically on intercepts 2 and 3, as Dr. Pinos mentioned, we also, if you look at the far left, there's the big white box that says diversion. And that really is, we also focused on intercepts 0 and 1 of what early diversion opportunities either were in existence already, or what might have been strategically created so that this competence restoration and competence to stand trial population can be treated prior to their getting involved in the system. These were the priorities for change that resulted from that SIM. The first is to develop strategies to reduce the use of inpatient competence evaluation orders and increase the use of outpatient competence evaluation. That of course is, as I mentioned, if you were to refer back 3 years when we started this, that was one of the high priorities of all of the communities, is to reduce the reliance on inpatient competence evaluation and restoration. The second was to enhance communication, training, and distribution of information about available resources. This really is to try to address, and this is certainly not just Alabama specific, this is in many of the states that we have been working with, is we know what we know in our silo, but we really don't know what happens in the other parts of the system. And so one of the priorities was to enhance that communication, to make sure that there was a communication across both the justice system and the behavioral health systems. Very early on, one of the assistant attorneys general who was involved in one of the state teams mentioned very early in the first year of community practice, he said, this might not be a very popular position, but it's good to know not everybody is in the same, or it's good to know that other people are in the same boat that we're in. So being able to communicate that, not only what the challenges are, but what some of the responses and opportunities are as well. The third priority is to develop a universal order of competence for competence evaluation. This is something which, again, is not specific to Alabama. This is also many states have as many orders for competence evaluation as they have counties in that state. And so one of the goals was to make a universal competence evaluation order so that all the courts would be using them. And then to increase more uniformity across the state. And so this was a fully virtual sim, which Dr. Pinels and I led with a lot of support from the Gain Center and from Policy Research Associates. And this is what was the main result of that sim. If any of you have been involved in a sim, you know one of the outcomes is a map. I know the print's really small on this, but as you can see by just the population of the number of areas of focus in intercepts 2 and 3, and how important intercepts 0 and 1 are also in not just who is being fed into the competence system, who hasn't perhaps been diverted or deflected earlier than intercept 2, but also that providing the feedback and providing the opportunities for people who already are in the system to then be diverted back to programs and hooked up with programs that already exist in the community. So this was, as I mentioned, this was an outgrowth of the request for doing a sim to focus on competence to stand trial. And this was the map that was developed specifically for the state of Alabama. So I'm going to end there. We have a couple of minutes before this session is over. And so if there are questions that came into the Q&A during the presentations, we'd be happy to address them now. I'm not talented enough to read the question and answer at the same time I'm talking. So I will take a look at that. So if you could submit your questions in the Q&A pod. We're not really responding to questions in the chat box. That just is a little bit of overload of input and output. So if you could move it over to the chat box, that would be great. So one question, and Deb, Dr. Pinels, I don't know if you want to, if you would want to respond to it, is what would be best placements other than the state hospital for those with who are highly symptomatic and unrestorable? Should it be the responsibility of the state hospital to manage this population and to make these placements, or whose responsibility should that be?
Yeah, I think that's a great question. And thanks for reading that, Lisa, because I'm having a hard time figuring out that Q&A. I guess I'm not that talented on the Q&A side of it, but the issues are so complex, because really what we need to figure out is if you just keep in your head, getting the person in the right place at the right time for the right reason. So, if you have somebody that's charged with a major felony, and people in the competency system can be charged with anything from trespassing to murder, that is going to be a challenge to manage somebody with a major felony in, let's say, an acute hospital, a private acute hospital. That probably wouldn't fly, or in a community-based setting. Not always, though. I've been amazed to see how different things can play out, but is a general rule. Whereas if you have somebody with lower level charges, do you really need the locked custody setting of a jail to manage somebody with, from a criminal justice standpoint? And some of this kind of overlaps with some bail and bond issues that states are trying to grapple with. From a psychiatric perspective and a clinical perspective, if you have somebody with serious mental illness who's acutely psychotic, and that can mean somebody who's completely behaviorally dysregulated, or it can mean somebody who's very quiet, and they're too depressed and suicidal to make a peep. So you can't judge it based on management. You have to look at the clinical needs of that individual to say, does this person need a hospital level of care? And it's very difficult because the hospital level of care and the locked door of a jail do not provide the same resources, both from a public safety standpoint and then from a treatment standpoint. So you're really trying to get what's the best place to manage all those issues. And to me, the system, the community is responsible for thinking through their options in terms of who can be in the community and who needs that locked door of a jail and who needs, you know, a locked setting of a psychiatric unit. And so it's not as much about the state hospital versus, it's really about, do they need a hospital at all? Many people in the competency system don't need a hospital setting clinically, and they don't need a jail setting, but because they're in the forensic system, they end up waiting in jail for that hospital bed.
Thank you, Dr. Pinos. We had a couple questions also that I think might be able to be blended together. They're related in addressing the issue of objections to medication, both in the community or in the jail. And also connected to that is how families might be involved in the process with it becoming complicated when people are objecting to their, to the recommended treatments.
Well, I would just say we don't want to treat forensic patients any differently than we are with any other human that we're working with who has serious mental illness, in the sense that people who are competent to make treatment decisions have a right to make their own treatment decisions. And what we try and do in mental health care is engage people in adherence. The challenge is that in some settings are more adept at engaging people in adherence. So for example, a psychiatric hospital where you have trained nurses and a multidisciplinary treatment team, engagement and adherence is going to be kind of part and parcel of what they do. That's not going to be as feasible always as in a jail. There are some really interesting studies, though, looking at certain jails that have worked really hard to get all their staff rallied around treatment adherence to help that person be willing to take their medication. There are also provisions in the law, and they differ across states, regarding treatment over objection related to restoration, as well as treatment over objection, just generally speaking, having nothing to do with competence to stand trial. And and again, these are kind of nuanced areas, but that's why a multidisciplinary approach is going to be necessary to sort out what's the legal regulation of that psychiatric practice. And it maybe sounds complicated the way I'm answering it. It can be, but I think, again, if you get multiple stakeholders together and look at your laws and get your best treatment professionals from a multidisciplinary perspective and get that input from families and people with lived experience, I think you can really carve out some fantastic strategies.
Thank you. Another clinical question. I warned Dr. Pinos that I think most of the questions are going to be toward her because she's the clinician and I am not. So another question came from Colorado that that many patients who are in quotation marks malingering end up at the state hospital to create space in the jail-based restoration program. What routes would you recommend to avoid this process?
Well, in forensic training, we spend a lot of time learning about how to do the assessment of malingering, and that becomes an important thing to think about. However, I guess I have to say, in my systems hat, sometimes I look at malingering as an adaptive strategy to remove oneself from a difficult situation. And, obviously it goes beyond restoration. Your evaluators should be able to do the best assessments to figure out whether somebody's malingering. But at the same time, this may be an individual with real needs who is using that strategy as a cry for help around other kinds of needs. It may not be, it may just be a way to get, some people would say it's a way to get, quote, good time. I don't think being in a locked setting in any of these settings is kind of a good time. So I think, it's often helpful to have the treating professionals, not the evaluating professionals, kind of look at what are the motives and what's going on that might be helpful so that we reduce the likelihood of that person, using that strategy as a coping strategy. It can be adaptive to try and get out of a jail setting and do what you can to try and get out of a jail setting. So, we really, working with a lot of sheriffs trying to make the jail treatment issues more, make the treaters within jails more aware of how to work with this population as well is going to be another strategy.
We had also a question both right now and also in the or during registration questions around how people with TBI fit into this competence process and treatment.
Well, if you look at the competency population, you're going to see probably many of the individuals have a traumatic brain injury. Whether that traumatic brain injury is the primary driver of their functional impairments or not, it could be part of the mix. We're learning a lot about the overlap of, personality disorders that involve impulsivity, as well as mental illness that involves that kind of impulsivity, irritability that might lead to traumatic brain injury or poor judgment. So there is a complex interplay with traumatic brain injury. The traumatic brain injury systems are typically different than the mental health systems. So you have somebody whose main issue is a traumatic brain injury, then they may not be eligible for services within the mental health system, because the mental health systems often look at sort of drivers of what's causing the functional impairment, and they work with people with serious mental illness. So again, this is where I think the executive branch might need to bring in stakeholders from a variety of different angles to help address the unique needs of these populations. And it's not easy. I mean, it's not easy. There's no easiness to this. It's just part of what I think the work needs to do as we learn more and get more sophisticated about how to help these situations.
Thank you. And we're getting some more questions that I know will be answered in some of the subsequent presentations. So I'm going to go ahead and skip over those. We have about 2 minutes left, and I just wanted to bring your attention to some resources as well. And I really appreciate all the questions coming through. We'll get to as many of them as we can, especially we have, after each of the panels today, we have a 30-minute period of time for discussions and question and answers. So we'll have a lot of opportunity then to dig into some of these. One of the resources I wanted to bring your attention to is at Policy Research Associates, which is the home of the Gain Center, we have a Competence to Stand Trial microsite where a lot of the materials that have been referenced and other articles and other kinds of information are posted there. So you will be able to, when you receive the slides, you will be able to link to this. This is a hyperlink in the slide, in the actual slide deck. So you'll be able to find that, or if you search yourself, you'll be able to find it as well if you go to the PRA website. At the end, I think Erica will talk about the certificate, but just as a reminder, this we do not award CEUs. But you will get a certificate of webinar attendance at the end of the day, and we will explain to you how to do that at the very end of the day. It isn't for CEUs because we're not an accredited organization for CEUs. Okay, as though magically it's appearing, there should be a window that appears that will have the file transfer for the, there it is, for the certificate of participation in this first webinar. So with that, and it's 1:15, I'm going to turn the microphone back over to Erica, who is the organizer of today's summit, and for next steps. And thank you everyone for your questions and for attending this afternoon.
Thank you. So we will, in just a few minutes, be taking a 15-minute break, and you can find us here again at the same registration link starting at 1:30 p.m. Eastern Time for the next presentation. And if you, as Lisa said, if you have, if you'd like to access the certificate of attendance, go ahead and click that download button on the file transfer window that just popped up on your screen. Make sure that you select the name of the file first, and it will turn a darker color, and then hit download. That will initiate the process to save the document directly to your computer. And next slide, please. I'd like to just let you know that this is where you can sign up for The Gaines listserv, this is where you can stay up to date with all of the Gaines Center's activities. Next slide.
Erica, someone asked if you could put the download window up again.
Absolutely. And this concludes part 1 of today's summit. And we will be back here after a short break, and we'll leave the file transfer window up for a little bit. So for anybody who during the break would like to download the certificate, you can do that. And hope to see you back here at 1:30 p.m. Eastern. Good afternoon, everyone. Welcome to today's National Virtual Summit on Competence to Stand Trial and Competence Restoration, presented by SAMHSA's Gaines Center with the support of SAMHSA, which is the Substance Abuse and Mental Health Services Administration. We are about to begin the second of 3 consecutive sessions today focused on a review of the work, states' efforts to improve competence to stand trial and competence restoration processes. Our next panel is toward a comprehensive approach to competence restoration reform, operationalizing system-wide change. I am Erica Ihara, and I am a project associate at Policy Research Associates and SAMHSA's Gaines Center. And before we start today's session, I have a couple of housekeeping items to review. First, our disclaimer. The views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the Center for Mental Health Services, the Center for Substance Abuse Treatment, the Substance Abuse and Mental Health Services Administration, or the U.S. Department of Health and Human Services. If you have any questions for the presenters, please type them into the Q&A pod, which is located to the right of your screen, and we will be queuing up your questions and answering as many of them as possible during the 2 discussion groups that are scheduled for today. We will also be conducting a couple of polls, and we appreciate your participation in these. So when you see a poll pop up on your screen, if you would like to enter your responses, we will be sharing some of the results in just a few minutes with you all. This webinar is being recorded, and slides will be disseminated via the Gaines listserv following the summit. We will also notify you when the session recordings are posted to SAMHSA's YouTube channel. And a certificate of attendance will be available for download at the end of each session today. And just as a reminder to everyone in the audience, these certificates are for your portfolio use only, and they are not eligible for CEU credits. We have American Sign Language interpretation for today's summit. And to view our interpreters, if you don't already see them on your screen, go to Layout in the upper right-hand corner of your screen, select Hide Non-Video Participants, and then change the layout view to full screen. Finally, select View All. We have 2 interpreters today, and their names are Michelle Johnson and Megan Thorpe. There is live captioning for today's event. To view live captioning, select the Accept button in the multimedia pod, which is in the lower right of your screen. The color contrast can be changed as needed, and we recommend high contrast for best visibility. And next, I would like to introduce the agenda for our second session of the day. Dr. Deborah Peinels, whom we've just heard from in part 1, will moderate this next panel. And first, we will be hearing from Dr. Jenny Simpson and Christy Taylor from the state of Texas. Then Jennifer Simple and Linda Whitmus will present from Nebraska. And Deborah Marianov and Honorable Nan Waller will present from Oregon. And then we will move into the discussion group where we will address your questions from the audience. I'd also like to note that we have Dr. Lark Huang, who was very involved in this project from the inception of the learning collaboratives with the Gain Center. And so I'd like to also welcome her to today's event. And now I'd like to introduce our presenters. Dr. Deborah Peinels is clinical professor of psychiatry at University of Michigan Medical School, where she is also the director of the program in psychiatry, law, and ethics. She is medical director of behavioral health and forensic programs for the Michigan Department of Health and Human Services, and senior consultant to policy research associates in SAMHSA's Gain Center. Dr. Jenny Simpson, who is State Forensic Director at the State of Texas Health and Human Services Commission. Christy Taylor, who is Executive Director of the Texas Judicial Commission on Mental Health. Dr. Jennifer Simple, who is Program Director of the Forensic Program at the Lincoln Regional Center, which is a state hospital in Lincoln, Nebraska. Linda Whitmus, who is Deputy Director at the Nebraska Department of Health and Human Services, Division of Behavioral Health. Dr. Deborah Marianov, who is Senior Assistant General Counsel for Behavioral Health at the Oregon Judicial Department. Honorable Nan Waller, Judge of the Multnomah County, Oregon Circuit Court, and she is the Mental Health Court Judge. And I'd like to just share some results with some observations about who is in the audience today. Thank you to everyone who replied. So most of you this afternoon are calling in from an urban location, followed by just about an even split between rural and suburban locations. We have folks from multiple professional areas joining today, including those in the judiciary, policy, corrections, crisis services providers, hospitals, community-based organizations, public health, government, and other. So welcome to you all. And now please join me in welcoming our distinguished panel, and I will turn this over to Dr. Jenny Simpson and Ms. Christy Taylor to begin this afternoon's panel. Thank you.
Great, thank you, Erica. I'm really excited to be here today. Thank you for the invitation for Christy and I to speak with you. There we go. Okay, I think I have it now. Good afternoon, and thank you for having us here today. As Erica said, my name is Jenny Simpson. I'm the State Forensic Director in Texas. My position and office is responsible for providing oversight and coordination of forensic services, as well as directing policy and technical assistance to reduce and prevent justice involvement for individuals with behavioral health issues. And I'm really fortunate to be in my position to be able to work with Christy Taylor, who is presenting here with me today, to really think up some innovative strategies for addressing competency restoration in our state. Okay, I'm having a little bit of technical difficulty in how to advance it forward. Can I have there we go, thank you so much. So in Texas today, and this is a slide that is a little bit dated now, we have approximately 1,900 people who are waiting in our county jails for inpatient competency restoration services. And really to put this number in perspective, with COVID and workforce shortages impacting the capacity of our state hospitals, we have a bed capacity of approximately 2,100 beds across our state hospital. So it's not an overstatement to say that we do have a crisis in Texas. Also, currently, we have 70% of our state hospital beds are forensic beds. In 2006, that number was 28%. So over the past 15 years, we've seen a dramatic shift in our state hospital populations. We also have a significant number of individuals who've been in the state hospitals for over 365 days. Currently, nearly 600 individuals who are in our state hospital system for inpatient restoration services have been there over a year, many of them on commitments that have been extended by the courts with criminal charges pending. And with these commitments, the state hospital system has no decision making in when these individuals should be discharged. Our legislature has made significant investments in renovating our aging state hospital systems and building additional bed capacity, but infrastructure takes time. And the challenges in our state are like those in other states, but we're a really big state. And so I would say those challenges are pretty large as well. So first, and this really covers, what Dr. Pines went over, but people with mental illnesses are arrested when diversion is appropriate and possible. So looking at the wait list that we have in Texas, we have individuals who have been arrested for misdemeanor crimes in places where diversion programs exist. And so we are doing some research to find out why are those diversion programs not being utilized. But we ultimately really need to stop the flow of individuals into the criminal justice system who, with the right treatment and supports and with public safety in mind, could be served in the community. We also know that competency restoration is often believed to be comprehensive treatment when the goals for restoration focus on stabilization and ensuring a factual and rational understanding of the legal proceedings the defendant will go through, and the ability to consult with a lawyer. The use of alternatives to inpatient competency restoration is also not as robust as we would like to see in Texas. And finally, there are efficiencies and delays in the evaluation and restoration of individuals. In Texas, we see substantial time between when an individual has been referred for an evaluation and when that evaluation is completed by a forensic evaluator in the community. So with a state the size of Texas and really the need to change behaviors and practices, because that's what we're really talking about, is we have to change those behaviors and practices of our justice professionals, our behavioral health professionals, and we have to do it at both a multi-systems level as well as at an individual level. So what do you do? We think creatively and outside of the box and think about using the tools of public health. So where Christy and our teams landed was to develop a statewide initiative that targeted strategies to eliminate the wait for inpatient competency restoration services. So we knew that to really bring this initiative to the state, we needed a plan, resources to support implementation, and the ability to do targeted technical assistance to local communities and practitioners. And as part of that campaign and the technical assistance, we needed to incentivize accountability to following laws, statutes, and best practices. I'm going to hand it over to Christy now to talk about some of the legal complexities in Texas.
Thank you, Dr. Simpson. So the partnership with the highest level of our Human Services Commission has been really important, combining that with the highest level of the judiciary in our state. So I want to tell you, we have a judicial commission focused solely on mental health in Texas. It was formed in 2018 by the two highest courts, our Supreme Court of Texas and Texas Court of Criminal Appeals. This has been really beneficial to us to make a focus on the legal side of things. Now, Texas participated in the SAMHSA Learning Collaborative. We had help there was a task force from the Conference of Chief Justices and Conference of State Court Administrators, had a task force through a BJA grant on improving court response to those with mental illness. This sort of attention from our highest leadership is so important. We had our Chief Justice Hecht serving on that committee, and then being able then to give us his full support. So I will let you know that all of your states, the highest Chief Justice in your state, are meeting this January in Austin at their mid-year conference, and we will be doing a presentation on how to make a commission. If that is something that you think would be helpful in your state, we are more than willing to talk to you about it. We started very small. We started with one person 4 years ago, and now we're able to build to that. So that's all really helpful. So with that support, we were able to look at our statutory structure. Sometimes the judges and attorneys who hear about the lack of beds think this is not my problem. This is not about me. And of course, we know it is a complex multi-system problem. And even more than multi-system, we realized even in our own system, there was a huge divide between criminal and civil attorneys and judges, and a huge lack of understanding about what their actions meant for the other side. So we looked at our statute about competency restoration, and we found that some of the language that, like Dr. Pinel said, very well intentioned, very easily put people on that trial highway. And we began to look at that highway and notice that just a suggestion of incompetency began some processes where judges and attorneys who were following the law would feel like they were compelled to put people into inpatient competency restoration. So we are going to look at that as a state. We have just finished a legislative session, and with this next one, we're already looking at some of the other states' language to require that judges think about that they only use competency restoration for misdemeanors when it's absolutely necessary. Some sort of language to help with that part of the problem. And then, as Dr. Simpson said, we wanted to look at our practices, and we wanted to get a shared understanding around what was happening. Okay, can we go ahead and go to the next slide? We might need some help. Okay, so I'm sorry. I thought we were moving through this. This is the train that we were talking about, the highway to trial. And then we'll go ahead and go to the next one. So eliminate the wait was our state's opportunity to bring together diverse stakeholders to look at how we were all contributing to this problem with sometimes very small practices. Okay, next slide. We launched this initiative at our 4th annual Judicial Summit on Mental Health. Our JCMH has had conferences every year. This one had 1,500 or so participants. Like PRA had found, the use of the Zoom technology has allowed more people to come, but we had a good turnout, about 200 judges, 400 attorneys, and lots of other participants. We found our best and brightest in the state who were passionate about this issue and wanted to be champions, to look at their own backyard to say, what can we do to help with this problem? We held a roundtable before the summit and sat down and really gathered a lot of input. Okay, next slide. created a toolkit. And this is something that we intended to be very specific and promote that responsibility in accounting. We can go to next slide. So we wanted to promote that, I think I said accounting, accountability, where what we know is that if you use the language in the checklist that says, have you done this? Have you considered this? That people might look at that a little more specifically. So these checklists are divided into each discipline. Our staff took the lead on judges, prosecutors, and defense attorneys. And Dr. Simpson's staff wrote these checklists for sheriffs, police, and our local mental health authorities. We were very specific. We took those national best practices that we were gathering from all this good work, and we made it Texas specific. We made links so that it's easy to go read the law if you had forgotten what the law is. We wanted those best practices, some to be achievable and some to be aspirational. So for example, there are laws in Texas that are very well set up that just are not known yet. So we have a pretty strong statutory structure around early identification and notice when you find that someone may have a mental illness or intellectual disability, but their laws are not well known. We also had a process to transfer to civil system if the crime does not involve an act or threat of bodily injury to another person. Very little used statute. So these checklists try to draw specific attention to those, to say, look at all the diversion that you could use before you get to competency restoration. And we know that there are some cases that need competency restoration. So then in those cases, we try to offer efficiency procedures. Say, have you looked at an outpatient option? Do you have a jail-based? And again, that aspirational element of even if you don't have it, could you talk to your community about getting that? And so we're continuing this work through our legislative research committee. We have judges coming up with ideas all the time. We just had a meeting last week with a judge saying, when someone is transferred to, let's say Austin has a big state hospital, then they have to be transferred back to their community where they have jurisdiction if they regain competency. And with the onset of all this technology, our judges started saying, why couldn't we have those hearings available and in a conference or why couldn't we do it in the local community? So it's been very exciting to hear the ownership from all the different disciplines on how we could help improve this crisis in Texas. Dr. Simpson?
Great, thank you so much. So wanted to just, with the checklist, a really key component of the campaign was to communicate that everyone, from our treatment providers to law enforcement, jail administrators, and the courts had a role to play in reducing, and we hope, hopefully ultimately eliminating the wait for inpatient competency restoration services. Because we know it isn't just about the beds, which had been a large focus in our states. It's also about the systems and the practices used by professionals. And then we also, through the checklist, wanted to focus on the systemic drivers of the crisis. So we wanted to encourage diversion at all intercepts, but especially with our treatment providers and law enforcement. We needed treatment providers to consider offering outpatient and jail-based competency restoration and how they can better partner with the jails and courts to actively monitor folks. We also wanted our jail administrators to understand their role in providing medical care to prevent deterioration and the opportunities to identify and divert individuals at booking. And then we wanted our courts to better understand the purpose and appropriate use of competency restoration, as well as those alternatives to inpatient restoration. And really, that public health piece of this is all of these things require education. And so the toolkit was really that way to do a widespread educational campaign. And I'll say the toolkit also, and I hope that we're going to be able to share that, also really points out what our state hospitals are doing. And I want to say, to that end, one of the things that has really been it's such a key piece to how we reimagine forensic services in our state hospitals was that HHSC hired a chief of forensic medicine, and Dr. Felix Torres, who has really been focusing on this operational efficiencies inside of our hospitals, because those do play a role as well. Okay, so Where are we headed now? And so, just like any successful campaign that we've seen in the last few years, like Stepping Up, the MacArthur Safety and Justice Challenge, the Data Driven Justice Initiative, we need a really strong communications and implementation strategy. So we kind of had three approaches to this. So first, we really need to spread the word to educate and target our audiences. So that means working with the partners that signed on to this initiative. So the Texas Council of Community Centers, which represents our local mental health authorities, the Texas Police Chiefs Association, the Sheriff's Association of Texas, and then the multiple professional associations that represent court professionals. And so we really want to facilitate targeted learning opportunities that can inform on best practices using the toolkit. And then we need data to really drive behavioral practice change. So one of the exciting things as part of this, part of Eliminate the Wait, is both one advisory body to HHSC and the Judicial Commission both have data subcommittees. So we're getting them to help work on some data projects that really drill down into counties and how folks are actually placing individuals on our wait list, and getting down into around practices by professionals and leadership by judges. And so we'll be creating more tools and resources to help local communities. And then finally, we're supporting local communities with really targeted intensive TA that includes on-demand technical assistance and sequential intercept model mappings. The Judicial Commission has created a robust website that's based on the National Center of State Courts to serve as a repository of best practices. We have a TA center at HHSC that with our state agency partners that we will be building and standing up that will help us do learning collaboratives, things that really work, do those really unique and innovative state local practices to drive behavior change. And then of course we know that measuring success, how we are moving the needle is incredibly important. And we're focusing on how we can evaluate the campaign as well. So to end, I'm going to say we're off to a good start. Last week, our local news station in Austin ran a story on Eliminate the Wait and the partnership between HHSC and the JCMH. And I will say this is maybe one of the first times that we've had positive press around our wait list, and some hope that, at the state level, there's leadership to help drive down this wait list in a different kind of way, out of the box thinking. So I've asked if the Gain Center can share the link to that story, which also has a link to download the toolkit. Please do that. And here's our information. We hope that with the toolkit, tailor it, use it to your states as a way to bring a campaign to your state. And thank you very much.
Hi, I'm Deborah Marianov, and I am from the Oregon Judicial Department, Senior Assistant General Counsel there, and I'm going to be speaking about Oregon's statewide strategic action planning to identify resources and priorities, along with Judge Waller from Portland. I also wanted to note that at the Oregon Judicial Department, we have a team that works on behavioral health issues, so it includes myself. We have a behavioral health analyst, or a business practice analyst, a behavioral health data analyst, and specialists who work on specialty courts. We also have aid and assist coordinators in the courts. So we joined the Gain Center Community of Practice for Competence to Stand Trial and Community Restoration in 2020 with the idea that we wanted to create regional behavioral health resource centers, not only to address competence restoration, but also to more broadly improve coordination between the behavioral health and justice systems, and to try to fill some of the gaps in treatment and services for mental health and substance use disorders using a hub and spoke model. And the hub and spoke model that we wanted to use is one that is in place in some other states. Pima, Arizona has been a model for us, where individuals who are in a behavioral health crisis, instead of going to emergency rooms or jails, are brought to the center where there will be assessment, triage, stabilization, and then a warm handoff to the appropriate services. And Judge Waller is going to talk more about the model that we're developing in Portland that's called Beacon. For our behavioral health resource centers, our key objectives were to address evaluations for what we call aid and assist, so competence to stand trial. And that was to address making sure that people had access to evaluators across the state. We have concentrations of evaluators in some areas and then no evaluators in others, to make sure that the evaluations are timely. When in most of the state, they rely on the Oregon State Hospital to provide the evaluations. And because of capacity issues at the hospital, those evaluations can take a really long time to get back. And also evaluations for people who are on community-based restoration services. We don't have a setup currently within our statutes to require those evaluations or to pay for those evaluations. So we wanted to address those issues. Secondly, we wanted to expand deflection and diversion from the criminal justice system to reduce the risk of re-entry into the criminal justice system and the hospital emergency rooms. We wanted to ensure statewide access to appropriate services, both geographically, because the resources depend on what a particular county can provide, and there's a significant difference in rural areas from more urban areas, although none of them have enough resources. And then also cultural and linguistic equity to make sure that people have access to appropriate services and are culturally specific services. And then finally, we wanted to make better use of the existing state resources that we have. Oregon is in a position where it's on higher in the scale among states nationally of funding behavioral health, but lower on the scale of outcomes. And so we wanted to see what we could do to make better use of the funds we have, and then also to look at expanding the use of Medicaid to serve these populations better. While we were working on this project, we received technical assistance from the Gain Center, and the aspects of that that were most valuable to us, one was to collaborate with the other states, hear what the other states were working on, and get inspiration and support from them. I can't tell you how valuable that was. So just to have those connections. Second, to work on data collection and analysis needs from the very start of the project so that it would be integrated with how we build it and how we will evaluate it once we have it. And we worked with Dr. Richard Van Doorn on that. And then project facilitation generally. So we had Jennifer Johnson coming in from San Francisco, who worked with us in our multi-stakeholder groups, which was helpful because we're all coming at this from different places with different interests. And it was helpful to have a neutral expert come in and focus on the goals and how do we get there. So the timeline of our participation in the community of practice started in January of 2020 when we were selected. We put together both a statewide team to represent the diverse interests of the state that were involved in this area. And then we also put together 3 pilot teams that we were hoping would implement the idea on a starter basis. And we had one in Portland that you'll hear about, the Beacon Project, and then one was in Southern Oregon and one was in Central Oregon, both more rural areas. And so each of our groups were holding meetings over that first summer to think about the project, mostly the statewide group, but to a lesser extent, the pilot teams. In September of 2020, we completed our strategic plan, and our strategic plan broke it down into, we were going to have a 3-phased plan. We couldn't do it all in 1 year. Phase 1 was what we were doing. It was to come up with a conceptual plan of what behavioral health resource centers might do. Phase 2 would be to operationalize that and fill out the pieces of what that meant. And then phase 3 would be implementation. And we knew each of those would probably take at least a year to do. So in October of 2020, we started on phase 2 and started meeting with our group again and adding details to the plan. In January of 2021, our legislature came into session, and fortunately, there was an enormous focus on behavioral health this last session. The ideas that we had were in large part incorporated in a number of initiatives. And in the end, the legislature invested over $350 million into behavioral health. They adopted a number of different provisions. One of the things that they did was Oregon decriminalized most drugs. And so that if you're stopped by law enforcement, then you would have a choice of either paying a $100 fine or getting an assessment and then being connected to services for substance use disorders. And as part of that initiative, they were creating behavioral health resource networks, which sounded similar to what we were doing with behavioral health resource centers. And so for that and a number of reasons, we put our work on hold because we thought it would be more helpful to see where all of those initiatives landed and then work from there instead of recreating the wheel. So from that summer, when those were passed until the present, we've continued to work in the background on the forensic evaluation system piece, because that was one part that the legislature wasn't addressing. We've also been working with system partners to think about implementing the new legislative pieces that were adopted, and in particular to emphasize how important it is to consider the justice involved population as they were implementing that legislation. And then we also had a spin-off of starting to develop a statewide behavioral health summit, which was a budget note in the Oregon Judicial Department's budget from the last session, for us to think about how we could better integrate the justice system and the behavioral health system. And I'll tell you more about that summit in just a minute. The accomplishments that we had from the Gain Center project over 2020 and 2021 included, first, mapping Oregon's current aid and assist processes, services, funding, and identified gaps. And a lot of that work was done for us already. We have the Oregon Center for Behavioral Health and Justice Integration in Oregon that has been doing the SIM mapping workshops all across the state, and they had already completed 27 of them out of our 36 counties. So we were able to use that data and some other information to map out what our needs were. As I mentioned, we built a diverse, engaged, multidisciplinary coalition to work on Oregon's goals in the Gain Center. And Oregon has been blessed with a lot of interest by a lot of stakeholders to work together, and we have a lot of different groups that are working on the same issues. In fact, you'll see at the other green accomplishment is that we formed a statewide leadership committee to coordinate efforts among the related committees, councils, and work groups, because we wanted to make sure that we were all aligned and moving together. And so we started meeting monthly with the leaders, with the chairs of those various groups and their staff to make sure that we were all swimming in the same direction. As part of the Gains project, we considered model initiatives and systems in other states, and that was really helpful, both so that we could avoid recreating the wheel and also to lend credibility when we brought these ideas to Oregon to say they're successful elsewhere. We developed a strategic plan to conceptualize the regional behavioral health centers, and we broke that down into thinking about the implementation of the centers, the operations, and then the follow-up evaluation, recognizing that all three of those pieces were going to be important for our success. Ultimately, as I said, we paused on our steps forward as the legislature started to pick up steam. And so we were able to serve as an information resource to the Oregon State Legislature as they were implementing their behavioral health investments. We provided support from the state level to Portland's Behavioral Health Emergency Coordination Network initiative, Beacon, although to a large extent, they've taken that and run with it far beyond what the state has been doing. And so now it's reversed, and the rest of the state is looking to Portland as a model for what we could do statewide. I mentioned the statewide leadership. And then finally, we initiated plans for the statewide behavioral health summit to develop a model for integrating the behavioral health and justice systems. So essentially, the Gains project allowed us to start thinking about these issues and jump off in a number of different directions. Our next step for the Gains project are to continue working on improvements for Oregon's forensic evaluation system, to consider evidence-based practices to build culturally appropriate services, to build evidence-based practices for working with individuals who resist engagement in community restoration. And this is particularly for individuals who were receiving court-ordered services and are no longer receiving court-ordered services. There's been a disconnect for the community mental health providers to continue that treatment. And so then those people often will decompensate and back up in a revolving door back into the criminal justice system. And finally, looking at community restoration placements for challenging cases. So we know that individuals with certain types of offenses like sex offenses or arson are particularly difficult to place in community-based treatment. Individuals with co-occurring disorders, individuals with intellectual and developmental disabilities, individuals with neurocognitive issues, those are all more difficult for us for community-based treatment, and we're continuing to work on those. And then finally, maximizing Medicaid coverage for competence restoration services, and we're working with the Oregon Health Authority on their 1115 Medicaid waiver to try to have more coverage in that area. And then finally, we've been planning this behavioral health summit to envision a person-centered and integrated behavioral health and justice system that can address individuals at all levels, all parts of the system, when they're entering, when they're in the system, and when they're transitioning out. This is designed to align closely with the sequential intercept model. So the Behavioral Health Summit, which is starting on Wednesday, actually, is a two-part event. And our goal is to bring into alignment the three parts that we see as essential to have an effective working at the intersection of the justice system, the behavioral health system. And that is to consider the individual goals and values of the behavioral health system, the justice system, and individuals who are experiencing the system, to make sure that we can address the areas where they diverge and produce the best outcomes where they converge. So to that end, our goal is to produce two tangible work products. One is a behavioral health bill of rights for justice-involved individuals that would set forth the values of that population and the minimum expectations that they would have once they're in the system. And second, a model to integrate the systems that's going to better meet the needs specifically of the justice-involved population, that's going to look at some of the state structures that go beyond the policies and services and funding to think at the big pictures of what changes we might need. So this is just to illustrate what we're doing differently than what's already been going on in our state. The focus so far, and this is an umbrella overall of what we see is what's necessary for transforming our behavioral health system. So there's the levels of policy, funding, and services, which are all critical, and our legislature's been doing a great job of thinking about those things and investing in those things. But one of the things that it's difficult, because there's no entity that's in a great position to do this, is to step back and think about what are the big values, what's our ideal system, and what are the big governmental structures that we need to bridge those gaps. And so we're taking on that role through the Judicial Department to bring together diverse stakeholders to start thinking about those big pictures, and hopefully that will help better plug in the policies, funding, and services as we move forward. So as I mentioned, the summit begins this week. It's a two-part summit. We've tried to be innovative about the way we're approaching this, in part because of COVID, but just in part because we're trying to do things in a new way. So the summit is free. We have over 350 registrants so far. We've invited people who have personal experience at the intersection of Oregon's behavioral health and justice system and people who work in the system. And we've asked them to participate in both parts of our summit. So the first part of our summit is an online, on-demand series of modules. There's 5 modules. They look like websites where people will go on, they'll read about the different parts of the system, and then they'll have an opportunity to provide input using Mural, which is a web-based whiteboard application. And we've designed exercises for them to provide input. Then at the end of that 2 weeks, we will pull all of the input that they've provided, compile it for our facilitators, and have a 2-day live facilitated session where they'll be able to talk collectively about those modules and what they've learned and what they think as a group, try to reach consensus, and then work on developing our 2 work products. Those sessions will be co-facilitated by national experts, and we have the support of SAMHSA and GAINS financially and with facilitation, and we're very grateful for that. And we're pairing them with Oregonians who have lived experience to help facilitate each of those breakouts. In order to develop this summit, we put together a multi-stakeholder planning committee along similar lines to the GAINS group, because we knew that having that buy-in was going to be really important. And this group has served largely as an advisory board. Most of the work has been done, the practical work has been done by Judicial Department staff, the behavioral health staff that I mentioned, with some individuals, that other members of the group that have been able to help with various parts. So with that, I'm going to turn it over to Judge Waller, who's going to tell you more about the Behavioral Health Emergency Coordination Network that they're working on in Multnomah County.
Good morning, and thank you for giving me the opportunity, us the opportunity, both to learn during the communities of practice, and then to be able to share some of what we've learned and our experiences. Years ago, I went to a SAMHSA. I was working on a different project, and I went to a SAMHSA conference. And a SAMHSA official came up to me and said, "Oh my goodness, you're from Oregon. People from Oregon have such innovative ideas, but, and I was so pleased when you said that because we've been working on a big project for children, but sometimes you are lousy in the implementation. So my participation in everything that I'm doing related to behavioral health and the justice system is to make sure that Oregon is very good on implementation. And I think to date we are, with the wonderful work that Deborah and the rest of the behavioral health staff are doing, that we are getting much better on implementation, and that is our goal. The Behavioral Health Emergency Coordination Network is Portland's idea of what we need in terms of a crisis stabilization and assessment center. And it's called Beacon. There should be a picture of a lighthouse, beacon of hope light on this first slide. And if it was there, you would have that idea of what we are trying to do, and if you could go to the next slide, Deborah, I think that I don't have control, but yeah, I do. We're envisioning this as a network. So a place where people can go 24/7, open door, be dropped off faster than it is to drop off people at a jail, because we know that we need an incentive to get people truly deflected from the criminal justice system who are appropriately deflected. And so, for instance, a couple summers ago when I was handling our competency docket, over the course of the summer, I dismissed 70 criminal trespass charges from somebody who had significant delusions about the airport and would return every time that he could have a chance, every time he was released, every time he was arrested. It was about 12 miles to the jail, taken to jail, a lawyer would be appointed, charges filed. The first couple of times, evaluation, determination that he was unable, and because of the level of charge, the cases were dismissed. So I dismissed 70 charges, and in the end, what did we have? Somebody who got no treatment, somebody who continued to create an issue in terms of the community, and there was no stopping the process. In the end, he ended up getting civilly committed, which, and that's a story that has its own both upside and downside in his case. But we decided that that is a terrible waste of resources, terrible stress on an individual to be in and out of jail, in and out of the justice system with really no good end result. So that's our hope for Beacon, is that it will be that place where first responders can take people quickly, they can be stabilized, and then the network part of the approach is that they will be able to be handed off, because we all know that if you fix one part and you don't look at the next step of somebody's path, that you are not really keeping people out of any system, that will just end up with people clogged at that next point. So we want the network to be the community services and supports, housing, treatment that people can get so that they will not come back into the justice system. It is a complicated, I'm skipping one slide on purpose because you can look at it later. It's a complicated process. We have about 150 people, 70 agencies. As we were working on the Gaines project, there were also people in the Portland area who agreed that our community was in crisis, and we saw the results of that every day on the street of untreated people living on our sidewalks. We saw it in the jail, where there were far too many people with significant mental illness. We saw it in our state hospital, which has been facing lawsuits and under a federal injunction currently because of the difficulties in getting people transported on a timely basis. And so a lot of people had a lot of motivation to come together. But we know that everyone comes at a project like this with their own perspective, and we needed to come to common understanding, which meant getting everybody involved, getting to common understandings and agreements. And we are currently in phase 2 of our project, and we have a complicated structure. Our next phase is to really look at how do you bring together the city, the county, the state, insurance providers, community providers, people with lived experience, and develop a governance structure that is manageable. One of the things that I've realized as a judge, and I handled both our mental health court and our competency, and I'm sure that all of you have the same experience, is that oftentimes for many of the people who come into the justice system, the justice system is the only open door. And in building Beacon, what we hope to have is another path, another open door, so that people are not in that moment of crisis, in that moment of an officer responding to somebody in the middle of the street in meltdown who's disrupting traffic, to have an alternate place for people to go. And I urge all of you in looking at, as you create system changes, to really look at what does it mean to collaborate. It's not sitting at the table and all going back to their corners at the end of the day and hoping that there will be some common agreement. It is doing the work to really get people to change their systems. And I would agree with Dr. Simpson. It's changing our behavior, changing the behavior of all of the system providers. And so that is Beacon, and I'm going to take 30 seconds to also tell you that I would urge you to look at the work that's been done at the national level. And again, I agree with Dr. Simpson. We need those at the highest levels of government to be taking a look at the competency system and why we are all facing crisis. And in March of 2020, the Conference of Chief Justices and Conference of State Court Administrators passed a resolution establishing the National Task Force to examine state courts' response to mental illness. One of the first items on the agenda that the task force was tasked with was looking at the competency system. There's a report that has been approved by the executive committee of the National Task Force this last September, and I believe that it will be posted on the Gaines Center. If not, it's on the National Center for State Courts. There are 10 recommendations. The recommendations will all sound familiar to you because they're based upon the work that is being done in every state that is part of the community of practice and beyond. And I'm going to quickly go over the recommendations with you in 2 seconds. The first recommendation is to divert and deflect. If we have fewer people in the competency system, there will not be the possibility of as much clog and breakdown. The hydraulics will work better. And so for those criminal trespass cases, should those ever be getting into the justice system and having to go through an evaluation process? Probably not, ever. Restrict which cases are referred for a competency evaluation. Do we need everything going for a competency evaluation? Absolutely not. Develop alternative sites. Some people have all of the evaluations being done in the jail, which increases the acuity of people with pretty significant symptoms being in the jail. Are there other options? One of the options that I hope that Beacon will provide is an alternative place for those evaluations to be completed. And then develop alternative restoration sites. We have community restoration in Oregon. I know that many states are developing their community restoration programs. In order to do that, we know that we need housing, that we need supports for people, that we can't simply say the door jail is open, good luck, show up at an appointment next Tuesday for your community restoration. That will simply not work for many of the people who are very symptomatic. Revised restoration protocols. How are we getting evaluations done and how are we getting restoration services provided? We know that medication is often a necessary for many people to be restored, but what are the other kinds of services that will help support people? I'm amazed when I have somebody who's in jail. I did the aid and assist staffing this morning before jumping onto this, and people who are saying, nope, 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 never will take medication. We know when we look at what happens if people are committed to the state hospital that many of those same people start to take medication. So what are the therapeutic things that we can build into our restoration protocols to assist people who are resistant to restoration, including to medication? We know that we need to, develop and impose rational timelines. Dr. Pinels talked a bit about the Jackson case. States are all over the place. Oregon has, for a felony charge, 3 years of time if somebody's committed to the state hospital for restoration. As our hospital, state hospital has been facing lawsuits and mandates. We've seen that the there's been a speed up, and I thought it was just maybe anecdotal on my part in observing, but I think it's actually happened, that they are getting to findings of never able a lot faster, because they see that that is one of the things that will help in terms of reducing the capacity issues at the state hospital. So what is the right time to have somebody in restoration? Through our Aid and Assist legislative work group, we are looking at timelines both in the community and at the state hospital. Addressing operational inefficiencies. You know, are evaluators trained across the board consistently so that we're getting the same product? Are there evaluation templates that can be developed? Do we need multiple opinions? Some states, I've heard of some states that have had, at the end of the day, 9 evaluations. That's a lot of money, a lot of time, and a lot of resource being put into it. Are there case managers who can help people as they go through the restoration process, can assist in finding placement, can keep track of the data? And then court case management. We went to a centralized docket. So I hear all of the evaluations for our court. We have a rapid evaluation process where the evaluators are able to, the people that both sides trust are able to get evaluations done in about 4 days, which is much, much better than the sometimes 60 days that we are getting for evaluations when defense lawyers are simply picking them up. We all know that we are in a behavioral health workforce crisis, and we need to have better ways of training and retaining staff. We need to use data. And one of the things that I'm sorry that we don't have a chance to show you today from Oregon is an amazing Aid and Assist dashboard that is real time how each court is using. It holds us accountable when we see what we are doing in terms of the population. And then, of course, we need to develop a robust community-based treatment and support for diversion and reentry. We want to avoid people coming back in. And that was my speed dial of the recommendations from the National Task Force. I urge you all to take a look at them. We'll be developing some products to assist you. And I am now going to hand off to Nebraska and some of the amazing work that they are doing that I've had the privilege to get to hear about before. Thank you.
Thank you. Jennifer, are we ready to go here? My name is Linda Whitmus. I'm a Deputy Director at the Division of Behavioral Health. I'm joined by Dr. Simple today, who is a licensed psychologist and the Director for the Forensic Program at the Lincoln Regional Center. The Division of Behavioral Health is really comprised of 2 parts. One is the Regional Center, which is state psychiatric facilities, and then the other side is the community-based services. And so for our implementation of legislation, which occurred in Nebraska here in 2019, it certainly takes both sides of that system to implement legislation. Prior to the Nebraska applying for the Gains Initiative in 2019, we were seeing many of the same things that folks have reported here earlier today. We had a significant increase in the number of competency evaluation orders, as well as the referrals for competency restoration. Our numbers virtually doubled over that 2014 to 2018 period, both for evaluations and restoration. Competency can be ordered by either county or district court judges, and most folks who were ordered for evaluation and or restoration were remaining in jail until there was available beds at the state facility. The only option prior to the legislation that was passed in Nebraska was competency restoration in a state hospital or a state facility. Despite our efforts to look at processes, timelines, wait times continue to increase for us. And as Dr. Pinels reported earlier, our census and capacity at those regional centers or state hospitals was increasingly a forensic population. For probably 4 to 5 years prior to 2019, various bills had been proposed to modify state laws, but none of those resulted in any statutory changes. We had a little more traction in 2019, and the legislation strategy became a strong and central component to our one of our first strategies in year one of our learning collaborative. As I said, we had applied in 2019. You can see we had some very broad-based representation on that group, including the judiciary, public defenders, county attorneys, several of which who have been involved in proposing legislation prior to 2019. We also on our group had persons with lived experience and peer support who were able to be advocates for the outpatient option for individuals too. We submitted in 2019 and were accepted. Our identified priorities were to reduce our competency evaluations by 15%, reduce our wait times for competency restoration by 10%. These were based on baseline data, and we probably were targeting our targets were fairly aggressive. But as a result of the work that the group has done, we did get legislation passed, which was LB 686 in 2019, to allow us the option to do competency restoration process in the community. We, at this point, have a phased program where we're addressing some of the sequential intercept models 0 to 1, where we can maybe impact that competency restoration part. But right now, we haven't had a change in the number of competency evaluations. We have achieved a 30% decrease in our days waiting for admission as a result of the legislation and the work of the Learning Collaborative Group. We looked with our court administrators on data and developed a flow chart to develop the current process and where were we seeing lag times even in the days waiting for admission. This is both at the regional center, the hospital side of it, as well as in the court processes. That may be some of what you were referring to earlier in terms of dashboards for courts, which is something we have talked about as well. One of the things that was really interesting is developing a shared definition for even what wait time means. So we're talking the same language from between the hospital as well as the court system. I also want to add here that during the same time in 19 and 20, the state of Nebraska underwent a significant needs and gaps analysis for a new strategic plan for the Division of Behavioral Health, which has a strong component of it with the justice population. So it's interesting to me see some of the activities you are looking at in Oregon, because I think we would like to learn from a few of those as we move forward on our strategic plan. The legislation that was passed resulted in changes to our Nebraska revised statute, which is 291823, and it allows the Department of Health and Human Services to propose an alternative treatment plan other than inpatient or at a regional center in order to restore an individual to competency. This has to go into effect on July 1st of this year. We have entered into contracts with our community providers to offer competency restoration treatment. Dr. Simple will talk a little bit more about some of the criteria, the processes that we have done to implement this legislation. The major pieces of the legislation are as follows there. Should a judge determine that after a hearing the defendant is incompetent to stand trial and that there is substantial probability that they will become competent within the reasonably foreseeable future, the judge shall order the defendant to be committed to the Department of Health and Human Services. This is our forensic department at the regional center, to provide appropriate treatment to restore competency. This may include a commitment to a state hospital, another appropriate state-owned facility, or a contract facility or provider that is pursuant to an alternative treatment plan that has been proposed by the forensic department and approved by the court. The second part of this is that the department determines that treatment by contract facility or provider is appropriate. We file that report with the courts outlining its determination and that such alternative treatment plan with the court. And at a minimum, within 21 days after the filing of that report, the court shall hold a hearing to determine whether that alternative treatment plan is appropriate. The court is who approves or denies the alternative treatment plan. A defendant is not eligible for treatment by a contract facility or provider under this if the judge determines that the public safety would be at risk. And this was a big component when we were writing the legislation, as well as when we're going through implementation, was the public safety and the risk criteria that we would apply for an appropriate referral for competency restoration. Dr. Simple?
Sure, I'd like to highlight when Linda reviewed the statute language, the parts that were in italics were the parts that were changed. Parts that are not italics were essentially the same as what the old statute language was, but the italics is what was added when this bill passed. So after that bill passed, we switched our focus and rejoined the SAMHSA Gains Learning Collaborative in 2020. And at that point, our focus really switched to how are we going to implement outpatient competency restoration. So the law passed in 2019, but it didn't go into effect until 2021, as Linda mentioned. So we had some time to develop an implementation plan. We spent that time with the Learning Collaborative, receiving technical assistance, speaking to experts in the field, polling other states, looking to see what other folks had done successfully, so we didn't have to reinvent the wheel. At that point, we identified a target population that we were going to try to divert from inpatient restoration to outpatient restoration, looking at our current demographics that we had been tracking for some time on our inpatient restoration program. And also looked at developing what those actual alternative competency restoration programs would be in the community. Throughout the implementation in the last few years, DHHS contracted with the University of Nebraska's Public Policy Center to assist in development and implementation of outpatient competency restoration. Part of those efforts were conducting a series of stakeholder meetings with the judiciary, county attorneys, public defenders, community providers, and other interested groups or affected groups. We also actively work to recruit community providers throughout the state. Nebraska poses some challenges geographically. We needed to develop plans to implement outpatient competency restoration throughout the state, but there's a very small portion of the state that's urban and the rest of it's rural. And so trying to find the workforce who would have the capacity and the interest in providing that service has proven to be a challenge in the last year. But we spent some time recruiting, actively soliciting information, sharing information about what competency restoration was with community providers. Throughout the next few years, the last year and the next few years, the DHHS will maintain that contract with the Public Policy Center to assist with ongoing project evaluation, ongoing training and recruitment of community providers. How we've developed our outpatient competency restoration program essentially consists of three parts. Medication management, when and if needed. Care coordination is what we're labeling it, but that essentially refers to similar to case management types of services that an individual might receive. And competency-related counseling. So that could encompass general mental health counseling if that was necessary for competency restoration, as well as some basic education if understanding the factual elements of legal system were one of the barriers to competence. I'm going to go through a couple of the different approaches Nebraska is pursuing right now, but to kind of set the stage for that, in all three of these approaches, DHHS is going to maintain a few of the roles. As you saw in the statute language a few slides ago, DHHS has to provide the alternative treatment plan to the court if we are recommending outpatient competency restoration. Or if someone is in outpatient competency restoration and needs to potentially have a service modified, that they maybe need an inpatient program instead, DHHS will maintain that part of the
of the function. They'll make those recommendations. DHHS is also going to maintain the function of providing updates to the court regarding competency restoration. So to kind of set the stage for why we're currently pursuing 3 approaches for competency restoration is, I think Texas referenced this earlier, having both aspirational goals and feasible goals. And so when the legislation passed to allow us to expand competency restoration from a state hospital, it was essentially aspirational and then became reality. As in the last 2 years, we have also realized the workforce issues and other types of challenges are a barrier in actually getting outpatient competency restoration programs rolling and off the ground. So initially, Nebraska had intended to do number 1, have a standing contract with a community provider in various areas of the state to provide all 3 of those treatment components: the medication management, care management, and counseling services for competency restoration. We found some challenges with that. In a large portion of the state, we didn't have community providers interested in contracting for that service. So we came back to the drawing board to look at some other options. And that's when we came up with option number 2 and option number 3. Option number 2 includes a standing contract with a community provider to provide some of the treatment components. So an example of that is in one area of the state, we have a contract with a provider to provide care management and counseling services, but they don't have a medication provider and that available to that group. And so in that area, DHHS will provide the other component through some of the staff we have at the current state hospital. And then the third one is in an area, this will be preferred in an area where there's very few referrals, where it's a very rural area, where maybe a court refers somebody for competency restoration once a year, maybe less than that. We would be looking at a single case agreement, a contract to serve one individual for competency restoration for a portion of time. We recognize these 3 approaches will provide some challenges and potentially some additional support from the state and from the Public Policy Center in providing outpatient competency restoration. So we've been trying to be flexible with the types of support that's available and recognizing that this model will provide some challenges, but also allows us to serve folks in an area where there's just not an established provider group who's capable of handling a large caseload. And that essentially is the end of kind of our presentation from Nebraska.
Thank you. And now we are going to move into the discussion group. I'd just like to remind folks that if you have questions that you haven't sent to us yet via the Q&A, please go ahead and continue to do so until we end. We're going to end at 3:05 Eastern today, just to because we went a little bit over with the presentations, and we'll take a 10-minute break. So we've got about 24 minutes left for questions, and I am going to turn it back over now to Dr. Peinels to begin the discussion group.
Great. Well, first of all, I want to say how exciting it was to listen to these presentations, having been part of these learning collaboratives from the very beginning in the communities of practice. It's really amazing what the will of the people can do. And I loved hearing about, the brag and steal concept, where you get to hear about the great work that's happening in any particular jurisdiction, and then think about how it could apply to your jurisdiction. I'm also impressed to think about, the way you're all thinking flexibly, because I think that's really what it takes. What we're trying to do is create a brand new system that isn't a system that the current one was built on. The current system was built on entirely on the use of state hospitals for all of the services, evaluation and restoration services. And, that's just not the way we think right now. We really have to think about community first as a strategy for people who can be in the community for a lot of reasons and the right reasons. I was excited also to hear about Nebraska using some of their state hospital psychiatrists to help provide services in the community, because it really just triggered a huge memory for me of one of my first jobs in the Ohio system. We were assigned, I was an attending psychiatrist at the state hospital working on a forensic unit, And we were assigned, and I must admit, begrudgingly assigned, to cover a clinic in the community. And I have to say that was one of the best things I ever did, because it really taught me a lot about community mental health services in a different way. And it changed my way of operating even in the state hospital. So I love that breaking down of the boundary of thinking about, you know, these are the people we're serving are people that are moving through these systems, but the people working in these systems don't move as much as the defendants. And so oftentimes the defendants understand more about the complexities of the system than the providers. So I think the more we can train each other to think about what the barriers and limitations are in each of the systems and opportunities, I think the better we can serve people in these. So let me just see, I'm trying to figure out how to go with the Q&A.
Do you mean to suggest a question to start off?
Yeah, that would be great, because I don't know where to start with this particular panel.
Okay, so a question that came across both today and came across in the registration questions, and I think I would, anyone certainly can answer this, but I think I'd like to address it first to Judge Waller. Questions around how to work with from behavioral health professional standpoint and making plans and trying to change, like at the state level, you know, the resources that are available, et cetera. And how do you convey that to the local level judges and other prosecutors and defense attorneys in terms of that? Dr. Simpson also talked about needing to change behavior. How would you suggest, as someone who works both at the state level on a lot of the committees that were discussed, but you're also a Multnomah County judge, how do you suggest that conversation to go, or that work to go?
I think that it has been, thank you, Dr. Callahan, for the question. I think it's been invaluable to have the Chief Justice in Oregon put together a behavioral health advisory committee, and that's provided us the structure at the statewide level of working with local jurisdictions to on system improvement. And that information then is conveyed out to all judges, regardless of whether they're on the Behavioral Health Advisory Committee or not, which has been, I think, very helpful. We've tried to, we have a judge mentor system set up so that judges can sign up for the areas of expertise that they have. That's another way of being able to provide that information flow from the state level to the lower level. I'm hoping that the Behavioral Health Summit will help in terms of conveying some of the issues about how you work at the local level and what you need to do. We've suggested jurisdictions, and of course COVID kind of got in the way of what our intent was, but the local jurisdictions convene. Judges are great conveners because people generally show up if you call a meeting, and they don't ignore. And so I think that having that opportunity to call people together, and now we've all learned how to do it virtually. So there really is nothing that stops a judge from convening a meeting. We had been doing big meetings locally with both people from the state and local level looking at our competency process, which is how we got to the rapid process that has worked very well. We want to bring it up to even bigger scale than we're able to do it now. But I think that judges as conveners is a very, very handy tool to get people to the table. And then it's not just being at the table, it's getting people to the point where they understand that they are going to have to change their process and their behavior. I absolutely agreed with Dr. Simpson. And in order to do that, you have to come to some common understandings. The behavioral health system and the justice system have very different ideas on risk and what risk means. And so having those hard discussions about identifying, first off, the areas where there is not necessarily the same perspective, respecting people's mandates that they have to follow, and then seeing where you can come to common understanding and agreement on what risk is. And that's really been, I've loved the work that we're doing on Beacon, because these very large meetings that we have, lots of different kinds of meetings, but we've tried to get as many people involved so that all perspectives are at the table. We have a community engagement person who's developed a lived experience directory so that we have always the voice of those who we are going to be impacting at the table, including the business community, community leaders. So that we want all of those voices to be at the table, and that's what you can do, especially now in the age of virtual. But I would urge judges to use their convening power, and I would urge others in the behavioral health system to look to judges and ask for them to be that convener, because they will get both the justice system and the behavioral health system at the table.
Thanks. And Lisa, I think I've got my bearings on the Q&A, but we can certainly take turns. You know, for the states, and I'm not sure which state is the best one, but maybe I'll start with Jenny, even though it's a little bit of a judicial question as well. But when you look at Texas, either one of you, what happens with the voluntariness? If the judge finds that the defendant is incompetent and you're trying to do alternative strategies, is the defendant required to participate in the process as a condition of dismiss, or charges dismissed? How does one think through those issues as a stakeholder trying to drive change?
I'm going to let Christy jump in here too. Christy, you want to jump in? Christy is definitely, yeah.
Sure. So Dr. Punnels, you're saying, is it a voluntary decision by judges if they want to dismiss the charges, or if they want to, when they transfer?
I think the question was from one of the participants, and I don't know who's best to answer it, because you could look at this from the judicial angle, but I'm curious about how you're working with stakeholders, because, you know, is the competency restoration process voluntary? Once the judge orders somebody into restoration,
No.
How is that voluntariness? And I see Judge Waller, you're shaking your head. You may have some thoughts about this question, so feel free to take it if you're.
It's not voluntary. However, you can't, I mean, I deal with people every week who are saying, not going to take medication. They don't show up for appointments. And we are all trying to avoid further clogging the state hospital. So the solution can't be just, and we take the person into custody and then we transport them to the state hospital. We're defeating ourselves if that's the answer. We have status hearings where I feel like sometimes the pep squad of commending people for the good work they're doing, that they're engaged. And we find that that's been not 100% effective, but it is effective in terms of getting a judge's is showing an interest. I'm able to say, I understand, you know, that you did whatever today. That's great. Keep up the good work. But remember, you shouldn't be smoking marijuana while you're in your placement, because if you lose the placement, then you're going to be out on the street. We're going to start piloting that same process of status hearings for the state hospital, so that the recalcitrant participants in restoration at the state hospital, and there are some, whether they're malingering or whether they're just, you know, set dead on not taking medication. And we agreed, my court agreed, that we would start piloting that in January, in the hope that staying connected to their lawyer, to the court, realizing that we are still interested in what's going on with them and that we want to encourage their participation, will help. So stay tuned. We'll let you know how that works.
Yeah, that's exactly, that's a great answer to think about. And I guess that's where I was wondering, how are you guys in Texas also, or in Nebraska, engaging stakeholders to think about these issues? Because you do have this compulsory element for restoration, but then you have humans who, you know, may or may not want to do what you tell them to do. And how do you build that in? Because that's where I think people start to feel the risks are higher. If people aren't, you know, and that's the human tendency is to want people behind a locked door if they don't do, well, in this world of competency, you know, if they don't do what you tell them to do, you want to put them in a locked setting of some sort, as if that will solve your long-term problems. But what it often does is not solve them. So I guess I'm wondering from Texas or Nebraska if you have thoughts about that.
Christy, maybe if you talk about the dismiss and transfer, that's what I was thinking about. I don't know if you want to address that.
Sure. So I think our strategy with HHSC has been to create a menu of options and to try to describe who best fits each of those options. And what we've found is there's a huge disconnect between the policymakers and the on-the-ground attorneys, judges, caseworkers who are working with this. So one big hurdle for us was to take out our policy speak and to use that specific language on the ground. That we found out people were talking about laws, they were calling it 1622, and that didn't necessarily connect with, oh, that's your state's way to get early identification and notice. And so another thing that we're doing is both HHSC and JCMH is SIM mapping and really getting out down to that granular level. And for our commission, trying to look at those legal processes, such as what Dr. Simpson was referring to, is a dismiss and transfer. So we have a law already set up. It's actually been on the books for a long time, where a prosecutor can agree to transfer a criminal case to civil court. They can dismiss it or they cannot dismiss it, is the way it was written in Texas. So if there is a prosecutor who is resistant to dismissing it and they want to hold that, then they can go ahead and do that. But it's just not well known, and there's a big disconnect between our judges who do our early arraignment and our early magistration and our judges who end up hearing the trials. And so I think that SIM mapping process is a great tool to show, even if we're just working on a section, one intercept, how they relate to each other. And that's how I would reach the stakeholders.
Yeah, I think that's really helpful. I mean, we talk a lot about the continuum of care, and I think what we have to realize is there needs to be a continuum of options that are going to make, because every situation is different. You can have somebody arrested on a trespassing charge who's got a very scary background, and you can have somebody who's arrested on a more serious felony who really, if you look at the facts and circumstances of the case, it's not as alarming from a public safety perspective. And they may have different levels of illness or substance use. And so I love this menu of options approach that I think creates this continuum of opportunities for diverting people. Another question that came in before, from people that registered was, can someone please address how do problem-solving courts fit in to this? And at the risk of calling on you again, Judge Waller, since you were and have been a mental health court judge, maybe I will call on you to help explain the distinction.
Well, nobody can enter a problem-solving court if they are not competent, and you have to be competent in order to be able to make the decisions necessary to entering a problem-solving court. Although there are some jurisdictions, I think, around the country that are doing kind of a diversion without getting people to the point of competency, and if they participate, then the case will be dismissed. But a straight treatment court, like a mental health court, people have to be restored before they get in, because they're going to, if it's not a diversion case, and even if it is, they have to be able to make some decisions that are pretty important decisions. For our court, they have to be able to get through a plea hearing, and so that requires competency. But I will say that the aid and assist docket, since I do both dockets, is fertile ground for a mental health court. And so that's been one of the things that has been very interesting to see as people are restored, and they are, they're used to dealing with me, and they're saying, I want to go into mental health court. And so we've been able to do a really smooth transition. Most importantly, we've had some of the same staff working on the competency docket and the mental health court docket, so they can smooth the way so there's not some abrupt transition of no services and no support in place. And so it's been a very smooth way of bringing them into mental health court, which helps sustain the progress that they made during the competency process.
That's great. Another question that came up is the issue of using these strategies or various strategies for rural counties versus urban. Maybe I can toss that one out to Nebraska to see, since you were describing different challenges you had in different regions.
So I don't know if Linda wants to jump in, but it has been a challenge. So what we've done is kind of divided and conquered, try to find personal relationships when we can, or find cases that oftentimes community providers were already working with an individual. These are people that are well known with the community. And when they recognize, part of, I think, some of the hesitancy of community providers has been that the individuals involved in the criminal justice system, so that they're labeled as more scarier than a general mental health client. And when they realize that the folks that are getting referred, and we had criteria established and reviewed that with all of our providers that we were trying to recruit, talked about the kinds of individuals they might see. They recognized they were very similar, sometimes the same individuals that they'd already served in the past. And so I think that that helped, but it's still a work in progress. So we're still actively outreaching to different parts of the state. Linda and I and Dr. Mario Scalora has been our partner at the Public Policy Center, have been, calling, emailing, fielding questions, anything they want to do to just try to decrease reservations, increase knowledge about what we're proposing in the program, and trying to smooth the way. We've also been doing stakeholder meetings with county attorneys and defense attorneys. We presented at the Fall Judges Conference here in Nebraska to try to both educate, inform, decrease hesitation. I highlight the public safety issues that we've taken into consideration, and really be a resource at any stage of the game so that people are more comfortable with what we're proposing.
Can I jump in on that one too?
Yeah, absolutely.
Because for Texas, I mean, we're 70% rural in our state. So that is, part of the option to go very hard on technical assistance too, is so that we can build some of those relationships to really push out best practices. So I know, we're doing a TA center that will incorporate a lot of this work into it. Christy is as well. One of the things that we started, and it was specifically for rural communities, was a jail and reach learning collaborative. And so this is my team, and I mentioned Dr. Felix Torres, his team in the state hospital system that does the forensic medicine. We worked with 13 rural counties who brought their partners from sheriffs and jail administrators, courts, the local mental health authorities. We brought them together in this learning collaborative. It started with a 4-week training series on how to actively monitor the wait list, as well for individuals who with stabilization with medication, there might be evidence of immediate restoration. And so then our state hospital team, if appointed by the court, could do the reevaluations for free. That was that is a big draw of it. And so we're doing monthly technical assistance calls from October to June. And so for us, we've really kind of pushed in on developing like state local collaboration. And again, I just keep on highlighting, it's about behavior change and training and helping educate people on some new processes. So we plan on future learning collaboratives also. And again, just really targeting those rural communities with SIM mappings as well, and helping, our urban counties have a lot of those best practices going. And I think for us, it's really focusing in on our rural and suburban counties as well in Texas.
I love that idea of just trying to help. Because a lot of times this is a lack of, people are just not aware. They haven't had the advantage of all these conversations. And once you start hearing them, you really do get excited about the opportunities for change, and then also have strategies for making those kinds of changes. And so I think that's great. I guess I know we're going to run out of time soon for this great panel, so I'm trying to pick which question. They're all really interesting questions. Is there a thought that you have about strategies and this came from one of the pre-questions, at the evaluation level? Because what we're seeing is the pace of evaluation requests is not slowing down. And even if we develop strategies for restoration programming, that's only those defendants that are found incompetent and need restoration, and they may be able to be seen in the community. But any thoughts about the pace of evaluations and why that may be happening, and strategies to address evaluations as well as restoration? And I guess I could ask each of you to comment on that in no particular order.
I think that we need to figure out how to deflect more people, and I am sincere in saying sometimes the only door open. And I would agree with the comment that Dr. Simple just made. Sometimes people don't want people when they are associated with the criminal justice system. They think they are too scary. And so it's, I think, education, coming to common understandings of risk, deflecting those people who we can safely, we all feel comfortable and can reach consensus can be deflected, like my 70 crim trespass guy, that he should have been deflected early on if we had a place for him to go, but we had no place for first responders to drop him off. And I'm going to give a shout out to Harris County. We've really looked to them also for our behavioral health crisis center.
Anybody else? That's a great answer.
I'll jump in really quick. One of the things that, we are focusing, we have to move upstream. And, for us, also really focus on reducing and preventing justice involvement, because we are not seeing, the pace of individuals who are placed on our wait list go down quite yet. And so we know that one of the major strategy is to shut that front door. And so to that end in Texas, we've also gone in on developing a statewide strategic plan that's focused on diversion, community integration, and forensic services. And this has been, it's part of our statewide behavioral health coordinating council, which is 25 state agencies have come together to work on this plan and move this plan forward as, as state agencies, so that we're coordinating and coming together to really try to focus upstream as well.
Yeah, and one of the things I love about that, and I think each of you mentioned this in your own way, is that systems are getting more sophisticated around data to understand what those pinch points are, how many people are at those pinch points, to develop strategies around alternatives. So that's great. Anything from our Nebraska colleagues, since we got the other comments about the evaluation versus restoration pace?
I don't know that I have much to add other than what other folks said. Like, we talked about in our presentation, our goal was to reduce evaluations by looking at some of those earlier intercepts in the SIM map, but we have not been successful in doing that. We have not reduced our referrals for evaluations. We also, while we had, a really great moment in 2019 when we reduced our wait list times, COVID erased all that, and our wait list, has way bumped up. So what we have done, and I think one of our main evaluators for Nebraska is, I think, on the as a attendee today, we have worked on training the people who do most of our forensic evaluations through DHHS. We have worked with them on training them about what outpatient competency restoration is. We're trying to make the referral for outpatient competency restoration right at the time of the competency evaluation, if we can. That doesn't decrease competency evaluations at all, but we're trying to make the system more efficient.
Yeah, that's great. We worked also with our judicial leadership in Michigan around just the court order itself, which was an old document that kind of went to that default pathway, and worked on having check boxes that got the judges to think, are there alternatives here that are available in the community? So I think these are great strategies. I'm conscious of the fact that we're just a minute over time. Thank you so much. I'll turn this back over to Eric. I really appreciate our panelists and their wisdom and sharing their experiences.
Thank you, everyone. And as Dr. Peinel said, we are coming to the close of this section. I'd just like to point you to a couple of resources. First, the Texas's Eliminate the Wait Toolkit is about to be offered as a download. You should be seeing a file transfer box pop up on your screen shortly, and you can select that document as well as your attendance certificate if you'd like to download that. Be sure to select the documents that you like by clicking on them, and then the download button will turn a darker color, and just click that and they will begin saving to your computer. I'd also like to share in the chat the hyperlink to the piece that Dr. Simpson had mentioned a little earlier for anyone who may have missed it in the chat when we shared the link a little bit before. So that's there for you to peruse after we break. And finally, the Competence to Stand Trial microsite, when you receive the slides as a follow-up mailing, there's a hyperlink there, and you will be able to click it and access additional resources there on that site. So now, next slide, please. Here is the information where you can sign up to receive our e-news and other announcements on the Gain Center listserv. And finally, our contact information here at SAMHSA and SAMHSA's Gain Center. If you have any additional comments or questions for us, you should see a final poll for the day, for the session popping up as well. And if you would like to provide any input regarding additional TA or other areas where you would like information, you can complete that poll, and we do share that information with SAMHSA. So we're running a bit over time. We're going to take a short break, and we will be returning, let's say at 3:20 p.m. Eastern Time. And you don't have to relog in. We will be here at the same registration link just after the short break. So thanks, everyone, and we hope you can join us for the final panel in just a few minutes. Good afternoon, everyone, and welcome to today's National Virtual Summit on Competence to Stand Trial and Competence Restoration, presented by SAMHSA's Gain Center with the support of SAMHSA, which is the Substance Abuse and Mental Health Services Administration. We are about to begin the third of 3 consecutive sessions today, focused on a review of the work, states' efforts to improve competence to stand trial and competence restoration processes. Our concluding panel for the day is improving local competence restoration systems through incremental steps towards change. I am Erica Ihara, and I am a project associate at Policy Research Associates and SAMHSA's Gain Center. And before we start the event, I have a couple of housekeeping items to review. First, our disclaimer. The views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the Center for Mental Health Services, the Center for Substance Abuse Treatment, the Substance Abuse and Mental Health Services Administration, or the U.S. Department of Health and Human Services. If you have any questions for the presenters today, please use the Q&A pod, which is located on the right of your screen, and we will address as many of your questions as possible during the final discussion group, which is going to take place right after the presentations that you're about to hear. We're also going to be conducting a couple of polls, and we appreciate your participation in those. So when you see a poll pop up on your screen, if you would like to enter your responses, we will be sharing some of those results with you all. This webinar is being recorded, and slides will be disseminated via the Gains listserv following the summit, and we will also notify you when the session recordings are posted to SAMHSA's YouTube channel. A certificate of attendance will be available for download at the end of the session. And just as a reminder, these certificates are for your personal portfolio use only, and they are not for CEU credits. We have 2 American Sign Language interpreters for today, and if you can't already see them on your screen, go to Layout in the upper right-hand corner of your screen, select Hide Non-Video Participants, and then change the layout view to full screen. Finally, select View All, and our interpreters for today are Michelle Johnson and Megan Thorpe. We also have live captioning for this event, and to view live captioning, select the Accept button in the Multimedia pod, which is in the lower right of your screen. The color contrast can be changed as needed, and we recommend high contrast style for best visibility. And next, I would like to introduce the agenda for our final session of the day. Dr. Lisa Callahan, whom we've heard from in part 1 and part 2, will moderate this next panel. And first, we will be hearing from Dr. Philip Candelas and Dr. Chad Tilbrook from Washington, D.C., Tracy Ginn and Trina Ford Gaynor from North Carolina, and Tracy Moorer from Florida. We will then move into the discussion group where we will be joined by Aaron Rogoff from the state of North Carolina. And now I'd like to introduce our presenters. This event is being moderated by Dr. Lisa Callahan. She is Senior Research Associate at Policy Research Associates, and she has also been involved in leading this learning community since the beginning of the project, which has been for 3 years. Next slide, please. Dr. Philip Candelas is Professor of Psychiatry and Behavioral Sciences at George Washington University School of Medicine and Health Sciences. Next slide. Dr. Chad Tilbrook is Director of the Forensic Services Division, DC Department of Behavioral Health. Tracy Ginn is Mental Health Program Manager for the North Carolina Division of State-Operated Healthcare Facilities Psychiatric Hospital Team. Trina Ford Rayner is Program Consultant for Capacity Restoration with the North Carolina Division of State-Operated Healthcare Facilities in North Carolina. Tracy Moorer is Adult Care Coordinator of Pre-Commitment at Northwest Florida Health Network, which is located in Florida. And Aaron Rogoff is Associate General Counsel for North Carolina Department of Health and Human Services, supporting the Division of State-Operated Healthcare Facilities full-time. And I'd like to share just a couple of observations about who's in the audience today. Thank you to everyone who responded. Most of you are calling in from urban locations, followed by rural and then suburban locations in the smallest category. And we have many professional affiliations in our audience, those from the judiciary, policy, corrections, crisis services providers, hospitals, community-based organizations, public health, government, and other. So thank you to everyone who responded. And now please join me in welcoming our panel, and I will turn this over to Dr. Philip Candelas and Dr. Chad Tilbrook.
Good afternoon. I'm Chad Tilbrook. I'm the Director of the Forensic Service Division for the Department of Behavioral Health. And today I have with me my colleague, Dr. Phil Candelas, who together we will both be presenting the District of Columbia's Outpatient Competency Restoration Program and some data on its success. Fortunately, we have some professional guidelines on what to expect from an ideal OCRP. Apple and both Apple and the American Bar Association have offered guidelines many years ago, and all these guidelines agree that competency evaluation and restoration services should not be used for the purposes of linking defendants to treatment. That would be inappropriate, and there are better, less costly ways of handling that type of situation. They also agree that defendants should not be involuntarily hospitalized unless there is a clear evidence that inpatient competency restoration services are the only option, that it's medically necessary, that there's safety-related issues. Those are the only reasons why somebody should be involuntarily hospitalized for restoration services. Restoration services should also be provided in the least restrictive setting and only until the defendant's competency has been restored. Now, in the district, for those of you in attendance today whose state does not have an OCRP, I provided you with some references here to the Title 24 that we have here in the district that you'll be able to reference at the end of this presentation when we share the recorded presentation. DC is very fortunate to have a two-stage competency to stand trial screening process through our court clinics. After an individual has been found incompetent to stand trial through that process, and if they're still likely deemed to be able to attain a competence in the foreseeable future, they can either go to the hospital or to the Outpatient Competency Restoration Program. The OCRP, to make it simple, has some very interesting language that is placed in the court orders. And I'm sharing some of that with you now. The OCRP orders specify a date of the intake, that on or before such and such date, you, the defendant, must appear. The order also specifies the attendance requirements, that you must attend the OCRP sessions Monday through Thursday, and you will be required to attend a 1-hour session 4 days a week until further ordered by the court. You also must be in full compliance with mental health treatment as prescribed by DBH, and you also must be reporting for monitoring and substance use testing as required by the probationary arm of in DC, our pretrial services agency. Now, the OCRP in the District of Columbia has been in existence since 2009, and it's been running consistently for the last 12 years. We have approximately 100 new referrals coming through the doors each year, and we serve about 175 folks individually, individually annually, yes. It doesn't take a lot to actually run one of these programs, at least a lot of staff anyways. Our staff are comprised of one licensed mental health professional, a program coordinator, one non-licensed subject matter expert, and one part-time forensic psychologist. So essentially for 2.5 FTEs, we're able to run a program to this extent for the district and actually get quite a number of people through the door and back to court pretty quickly. The way the process occurs is that the defendant appears for intake. We identify the individual's behavioral health history and individualized barriers to competency based on the competency screening report and the staff's own observations of who presents before them. The restoration groups occur 2 times per day, 4 days per week, and these groups include 12 semi-structured psychoeducational modules. It's a multimedia aids, including various photographic, audio, and visual aids. They include interactive exercises and group discussions. And throughout this entire process, there's routine reviews of that material to make sure that the defendant is learning what was previously discussed. We also deal with defendants' nuanced or idiosyncratic rational understanding deficits through individual breakout sessions. The program also offers an experiential component too, including weekly mock trials where the program participants assume different roles of the courtroom participants through a hypothetical case vignette. Sometimes our DBH lawyers attend these programs, these mock trials, and play the role of the judge. And frankly, the feedback we've received from the program participants is that this is one of the most effective components of OCRP, as it actively engages the defendant to assume multiple different roles through the course of their participation, and it underscores the important and rather unique roles that they should know the difference of in the courtroom. In addition to these routine interventions, the OCRP also offers specialized remediation practices. For example, we offer the Slater method, which is an empirically based competency restoration program for individuals with ID. And the forensic psychologist will conduct a competency evaluation report approximately 1 week prior to the defendant's return. Even after the evaluation has been completed and submitted to the court, the defendant is still expected to participate in the program unless otherwise ordered by the court. It's a couple of things I'd like to highlight. Our OCRP in the district does not offer any direct mental health services. We do not offer medications. We do not offer therapy. We do not offer care management services. We do not offer transportation services. So these things may be a significant barrier to other states that are listening. However, what we do, our staff is in very close contact with and coordinates with other community providers, and in emergent situations where the defendant is experiencing a crisis, they may be referred to the urgent care clinic, which is right in the same building. The benefits of this program are very clear. First, on the individual level, the staff are able to monitor the progress and the individual's ability to understand and rationally participate in their program, in their upcoming hearings. They're able to monitor the progress of their mental health treatment to see if additional services are needed, and then they can go ahead and coordinate with the community providers. And OCRP also aims to set up the social and behavioral expectations for what the defendant should expect to see or should be expected of the defendant in the court. On a systems level, OCRP clearly is the less restrictive alternative. It offers less encroachment on the person's liberties. It is less disruptive in their daily life than the hospital is the other option. OCRP reduces strain on the limited bed space at our hospital. The quicker we can get an individual into programming and address their underlying barriers to competence, the quicker we can turn them back to court to continue with their adjudication process. There's a significant cost savings as well. Inpatient treatment costs almost 3 times as much as our outpatient competency restoration program. So who are the ideal candidates? Well, those who are not considered to be high security risks, individuals who are actively participating in mental health and or substance abuse programming in the community, and individuals, of course, who would not be too disruptive to the group process. But despite our successes, we still face some challenges. Even though there's an order commanding the individual show for the intake, show for the groups, we still struggle with quite a number of no-shows. And the judicial response to these no-shows is either a reprimand, some type of scolding, a slapping of the wrist, told to return back to OCRP for the next cycle, and that doesn't always work. And at the other end of the spectrum, of course, we have the bench warrant, which kind of reduces the whole point of the program. So we do struggle with our no-shows, but I found some ways of cutting into that problem, and I'll share those momentarily. Our defendants also struggle with substance use, and that substance use has both an indirect and sometimes a direct effect on their ability to participate in the program. And furthermore, if a defendant is not linked to services or is not adhering to any mental health treatment in the community, that's a challenge to any outpatient program. So we have tapped into this or devised a strategy to address these no-shows, and it's pretty simple. Essentially, if the defendant does not show within 5 days of their intake appointment, we simply send an email to the defense attorney and the prosecuting attorney and just inform them of the no-show. And I'm not sure what happens behind the scenes, but oftentimes that person will appear the following week. So that simple email correspondence with the legal parties has actually reduced our no-show rates by 50%. We also routinely comb through and update all of our learning materials. We create new and alternative learning modalities, board games, Jeopardy, bingo, whatever we can do to keep the participant engaged. We also work closely with our law enforcement supervision agency, our pretrial services agency, and we've identified a few gaps that we've been able to plug. We have everybody who's referred to the OCRP is now placed on the special supervision unit or the mental health caseload. And by doing so, we've identified a point of contact with each agency that we can actually share critical and time-sensitive information to. We also have efforts at increasing the continuity of care as well between not only our pretrial services agency, but also the community providers and, of course, DBH. And recently, we've also asked our court clinicians who conduct the detained evaluations at the jail to make recommendations when appropriate to OCRP. Now, these are only recommendations based on clinical need, and we are not making any recommendations related to bail or dangerousness. All right. Next, I'm going to turn it over to Dr. Candelas to report on some of the data.
Thank you, Dr. Tilbrook. Thank you, Chad. And while we have the floor for a second, just to thank Dr. Callahan for her guidance and availability over the last few years. Lisa, you've been there for conceptual issues, policy issues, technical advice, much appreciated. And to Erica Ihara for setting us up and getting us through this presentation. Our jurisdiction is particularly interested in outcomes assessment, and we have an academic component, we have statistical consultants, and if there's any way I can recommend, advise, advocate for programs that have tight connections, relationships with good data analysts and epidemiologic statisticians, I would take this opportunity to do that. Our technical advisor was Rumen Veselinoff at University of Maryland next door here, and he was just terrific in taking up a previous study that we published and getting us ready to publish. We've now published the follow-up. So we had a study in 2015 where we looked at about 4 years of data in outpatient competence restoration. And we wanted to see how things were progressing after the changes that Chad has been talking about. So there were more sessions, there was more one-to-one access, there were adjustments to the Florida comp kit that we used as a model, and our referrals were doubling. So we were interested to see how we maintained our function and whether there were any improvements or changes. So, we do simple demographics. We didn't have to do a lot of matching for the people who were referred. They were largely the same group in terms of their percentages. Ours is largely an African American community, and the referrals are largely African American, male, of a certain age, between 28 and 68, and that really didn't change. In terms of the age, the major age groups weren't different from one 4-year period to the other. The 2 slight changes that were significant were referral for more of younger people during the second period, and of older. So we've taken steps to develop a juvenile competence restoration program as well. And that you won't be surprised, many of you who are on today were part of the Learning Collaborative with us. Most of the referrals were for misdemeanors, and this was not a difference statistically significant from one 4-year time period to the other. Ours is a jurisdiction that's not just felony only, as some jurisdictions are. In terms of the diagnoses, those 2 remained similar, not statistically significant. Large numbers of thought disordered folks, a smaller number of cognitive, mood disorders, and then other personality disorders, substance use. Our demographics aren't different from many of the other programs that we've been talking to over the last few years. And restoration by diagnosis, again, not surprising that developmental disabilities, cognitive troubles are going to have very low possibilities of restoration. Thought disorder, mood, the other, again, the personality, substance use, more likely to be restored. And we're eager for your observations on developmental delays, because we think that those diagnoses in particular just keep people in the system for long times, for long periods. That it's very difficult without specific programming and specific resources for that group, that population, to make headway in restoration. That becomes a problem in this data that I'm about to show you. So here's the comparison between the previous restoration outcomes of the previous 4-year period and the more recent one. I'll direct you to the blue. We'll start from the bottom. So look at the blue bars to begin with. Our restoration rounds are 30 to 45 days for an initial competence restoration. That's the length of the court order. And then it's 30 days for each round after that, generally speaking. And in our first study, there was a statistically significant drop between the first and the second round. So we were very successful in restoring people in the first 30 to 45 days, and then less restoration happened in each following round. But what you'll see in the red bar graphs, is that this was much tighter this time. We were able to recruit more and more, to restore more and more people round after round. And indeed, even though there was a slight drop off after day 105, after round 4, there's still significant work being done. In fact, there is work being done. There is work being done into the 6th round, which we collapsed into this 675-day period, because the courts had left open-ended some of the orders. So there were people stuck in the forensic system without a return to the to court. And even though we were successful in restoring a number of them, even a couple of folks with cognitive disorders, it raises the important policy question of how long you do this and keep people in the system. So 2 important issues. We seem, with changes to the system, to continue restoring people round after round. And we can keep restoring them for up to 2 years if you give us a shot at it. The question of whether that's adequate policy or even ethics is, I think, an outgrowth of this data. And just to give you a sense of the kind of back of the envelope analysis that our statisticians do and how important they are, this is exactly that. This is the back of an envelope analysis from our chief statistician from the first study, and that started us into the second, where he created essentially what's called a hazard function, kind of a survivability a curve that used for people surviving cancer diagnosis or any kind of diagnosis. And just putting the data in perspective for us, and doing a kind of regression that lets you know how many people you're restoring per day of restoration. And this is in fact what the statistics showed, that the probability of restoration, again, not statistically significant until it starts to drop off. And here, round 6, this lengthy period of just keeping people in restoration maintains that it shows the capacity of programs to do the work over time. And this is just how the statistics played out, just as the raw numbers were showing them. So we see that if you make changes in a program, you can pick them up in your outcome studies, in your metrics. We're still able to restore people after an initial period, which is an advance from our first study. And beyond a couple rounds, 3 or 4 rounds, there seems to be less capacity to restore people. But if you keep them in there long enough, our clients, our referrals, you can still make headway. The problem is that we're keeping people in the forensic system for periods that are longer than any potential punishment that they might be experiencing, especially if they're misdemeanor referrals. And locally, we're assessing how the standardization of our modules, of our educational interventions, and the increases in group sessions, the availability of one-to-one is specifically affecting our outcomes. And again, our appreciation to the Learning Collaborative and SAMHSA's Gain Center for this, for getting us published and bringing this data to you. I will turn it over to our friends from North Carolina, and we'll meet again in the Q&A session. Thank you.
Right, thank you. Took some notes during your presentation. Our friends in DC, we're feeling very fortunate to have worked with the collaborative over the past couple of years, and we're still learning from our other states. So I am Tracy Ginn, and I work for the state hospital team in North Carolina. I am currently in the role of acting assistant division director for the state hospitals. Many of you know my old supervisor, Laura White. She recently retired, so I've kind of stepped into that role, at least temporarily. So what we're going to talk about today is our efforts to improve and make our system here in North Carolina more efficient. So the North Carolina Division of State Operated Healthcare Facilities, which is the division responsible for the 3 state hospitals in North Carolina, has a strategic goal to address the expanding needs of individuals identified as incapable to proceed to trial. In North Carolina, we say that's ITP. It's the same thing as IST in other states. And our strategic goal will include implementing some new, innovative, and state-directed community-based and jail-based capacity restoration programming. Part of our strategic goal is that the system must be responsive so that individuals have access to evaluation and treatment in the most appropriate location based on their clinical needs and their current legal status. So part of our presentation today, we are going to share with you, we've realized for the past several years that we needed to make system changes across our forensic system, not only with our capacity restoration programming, but also with our evaluation system. So I'm going to speak a little bit about our forensic evaluation system, and then Trina's going to talk about specifically the changes that we're hoping to make in our capacity restoration programming. And then I will share at the end some of the other things that we're doing to help improve the efficiency and effectiveness of our whole forensic system. So currently in North Carolina, evaluations for capacity to proceed to trial are done basically in 2 places: in the community by certified community forensic evaluators, and in our 3 state psychiatric hospitals by our facility licensed staff, which includes both PhD psychologists and psychiatrists. Capacity restoration focused programming currently in North Carolina is only offered in our state psychiatric hospitals and not in other locations. So I echo our friends from DC in saying that we were very appreciative of the collaborative that we were part of the past 2 years. We actually, our state legislature several years before that had also asked us to review and make some recommendations for changes to our forensic evaluation system. So like I said, this is something that we've been trying to work on and improve for several years now. So as part of the collaborative, we set up several work groups in the state. One was to look at our evaluation system changes, one for capacity restoration changes, and one because we all know that without those supportive services in the community, a lot of things, best intentions don't always make it through to full fruition. So we also had a community services work group to look at those wraparound services that will help to support individuals in the forensic service system. The community services work group was merged with that capacity restoration committee in the 2nd year of the collaborative. So in these work groups, we tried to bring as many stakeholders to the table as we could. And this is just a list of some of the folks that were involved in that. We had our state forensic staff, we had judges, public defenders, state's attorneys, in central office for the Division of State Operated Healthcare Facilities, our legal counsel, Aaron Rogoff, who has been instrumental in helping us to really move these things forward. Our sister division, the Division of Mental Health, Developmental Disabilities, and Substance Abuse Services, because they're the ones that coordinate and oversee those community services I mentioned earlier. Our Medicaid managed care organization staff, which in North Carolina, services are locally administrated through these different managed care organizations. So we had folks from those organizations at the table. Some of the county mental health professionals in Mecklenburg are our most populous county and really our partner throughout this whole endeavor the past couple of years. Detention staff, advocacy organizations, and then we brought in subject matter experts when we needed to help the work groups work through barriers and see some different changes that we'd like to do. Some of the current challenges in North Carolina is that, as I mentioned, we have that bifurcated system where community evaluations are done by the certified community forensic evaluators, and evaluations are done by our state hospital staff, mostly in the pretrial evaluation center. As I mentioned in the report we had to do several years for the legislature, we did do a survey, and there were some concerns that existed that the community evaluations more frequently resulted in requests from the court for a repeat evaluation. So we're very mindful of there's a lot of duplicated effort that we'd like to try and avoid moving forward. So some of the changes that we're asking for, based on the work groups that we had over the past couple of years, is that we would like to make some changes to the North Carolina statute to support expansion of being able to do misdemeanor evaluations in different locations. And we would also like to try and establish 3 regional outpatient evaluation centers where all the ITP evaluations can be done in North Carolina. Now, that is, this is still a work in progress. We're still trying to see how to best implement those changes. Those are going to require a request from the legislature in a future session. And our goal, of course, through all of this is to improve access and quality of all our forensic evaluations. And our key consideration with that is, how do we centralize our evaluation system in North Carolina? So as we continue to look about changing our evaluation system, we are going to continue to have stakeholder engagement and listen to concerns and thoughts and ideas from our stakeholder partners. We need to find funding to make these changes, because if we were to expand to additional locations within the state hospital system, we need to get funding. And we also need to look at any kind of legislative changes that might happen to occur before those things happen. And now Trina is going to talk a little bit about our capacity restoration changes.
Good afternoon, everybody. I would like to share with you some of the challenges we have faced here in North Carolina. One of them includes our state hospitals are oftentimes forced to delay admission of civil population patients to accommodate the court-ordered defendants who have been deemed ITP. Currently, in the state of North Carolina, there are limited opportunities that exist for individuals who are deemed ITP, and they do not meet the criteria for a state psychiatric hospital to receive focused restoration services. As a result of that, and in response to that need, North Carolina has set up a strategic and progressive plan for programming. Our plan is a 6-year pilot. Our plan is to implement 2-year pilot programs, 6 of them. The 3 will be community-based capacity restoration programs to be established through allocation letters to our local management entities and our managed care organizations. 3 of those will also include detention center capacity restoration programming to be contracted through 3 separate requests for proposals, also known as an RFP. Our focused areas are Cumberland, Guilford, and Mecklenburg counties. And I refer to these as focused areas because these are the areas where we see the higher numbers of individuals who have been deemed as incapable to proceed. Each county will correspond with one of our regional state psychiatric hospitals. We also wanted to create a program that will allow individuals, according to the need of care, if they are decompensating or their need is more acute. We would like to create a system where those individuals can get the care that they need in the appropriate setting. We also would like to identify long-term funding sources for these programmings, because of course we don't want something that we start and we can't keep it going for our community members who are in need. Some of the benefits or desired outcomes that we're expecting is that we would like to see a decrease in the need for law enforcement assistance with transportation. Currently in the state of North Carolina, our ITP patients are required to be transported by local law enforcement agencies. We would also like to reduce the court-ordered second evaluation. Tracy touched on it just a little bit regarding those evaluations, and sometimes having the court to request that we resubmit a evaluation on a patient's behalf, or due to the lack of determination because of concerns about the evaluation or poor report quality. We would also like to expedite court-ordered evaluations. We don't want someone languishing in different systems like our criminal justice system because they are waiting to be evaluated. We would also like to gain an ability to create a sustainable model in tandem with our Medicaid system. Additionally, cost savings. Who doesn't want to save money that can be put to good use in other areas? We would also like to expedite entry into treatment and reduce wait times for state hospital admission. Our last goal would be to provide high quality treatment with specialized trained staff in a safe environment and in accordance with best practices. Our metrics for measuring if we're doing our job and doing a good job would be used in comparison with national benchmarks. As indicated by the previous presenters from DC, individual and program data reporting would include individuals who were admitted, their charges and diagnosis, if that applies, their restoration rate and time to restoration, the capacity restoration programming average daily census. So if the individual is in a detention-based programming, we would like to know the census for that. The number of service hours that it takes to restore the individual, or service hours of treatment or programming that the individual is receiving. And the rate of court referrals of who initiated the capacity restoration services, rate of individuals who initiated services that complete services to disposition of charges. So here we're wanting to know individuals who make it to completion, and the rate of referrals, how many referrals we are getting, whether the individual completes or not. A rate of transfers between the Department of the Detention Center Capacity Restoration and state psychiatric hospitals. Again, we would like to have a fluid system where if the individual they leave the detention center and are in need of state psychiatric hospital services, we can accommodate that need. And lastly, satisfaction of participants and other stakeholders.
Another, go ahead.
Oh, sorry, I was going to turn it back over to you.
So another thing that we've been working on in North Carolina that we're excited about and we're hoping that we'll be able to have implemented by the end of this month is a forensic portal, which is an application-based portal for a cross-facility data collection and system-wide reporting of our forensic data. The platform will allow for the collection and sharing of relevant historical information. It will capture the ITP opinions, the time to restoration, capacity determination, and current barriers to an individual being able to be restored to capacity. And it also will allow for trending and analysis. It links to to our 3-state hospital clinical reporting system to maximize efficiency and exchange of information between the providers within our system. It will also calculate the minimum and maximum sentences for an individual offense with a time served credit accrued feature. which is important, knowing how long a person may be facing time and where we are against that clock with our capacity restoration programming. And it will also allow for facility-specific or statewide reporting. When we first launch our forensic portal, it will just be used within our 3 state hospitals, but eventually we're hoping to be able to expand that across the different systems to be able to really do that full data sharing. So part of our legislative ask for capacity restoration will be, we're going to ask for statutory changes which will allow for the capacity restoration to occur both in the community and in the detention setting. Currently, it's not prohibited, but we want to be able to make those changes to statute so that everyone will really understand where those options are available and start to make sure that everyone knows how to access them. And that includes creating a clear referral path for the courts so that judges, state's attorneys, public defenders will all know how to be able to access and the flow of information through the court system. We plan to submit these changes during what we call the short session in North Carolina, which will begin in the start of 2022. So there's a couple of the things that we're really hoping to implement in the next little while, which we think will really help support all these changes that we're trying to make. So the first thing is that we currently don't have a director for forensic services in North Carolina. So we are hoping to establish that position very shortly. And this position will oversee all the evaluation and capacity restoration activities for the state. And that position will be housed within the Division of State Operated Healthcare Facilities Central Office. The other thing that we want to do is fully utilize that forensic portal for direct data collection. As I said earlier, we're hoping to have that implemented within our 3 state hospitals by the end of the year, and then facilitate the consistent data collection across all the different sites by the end of 2022. So we thank you for letting us present about our programming and things that we're hoping to implement in North Carolina in the next couple of years to really be able to expand where and when individuals can receive forensic services. And we hope that that will help maximize both our civil and our forensic services in the state. And now I'm transferring over to Florida.
Introduced me earlier. I'm the pre-commitment adult care coordinator with one of the managing entities in Florida, and I'll get a little bit more into that as we proceed. All right, so in Florida, Florida's behavioral health, mental health system of care is governed by Florida Department of Children and Families, which is headquartered in Tallahassee, Florida. And if you're not familiar with Florida, or if you are, Tallahassee kind of sits in the middle. And then the services in Florida are delivered locally through contracts with community substance abuse and or mental health providers. We call the Office of Substance Abuse and Mental Health SAMH for short. And so services through SAMH are administered throughout 20 circuits statewide, which are grouped into 6 regions throughout the state. And throughout the state, there are 4 state forensic mental health treatment facilities. So we have 4 facilities for the forensic population. And then we have 3 additional facilities that we call forensic step-down facilities, where the individual can still be under the legal status of incompetent to proceed or not guilty by reason of insanity and be stepped down into sometimes our civil admission beds. And those would be individuals that travel through the system of care by way of Baker Act. In Florida, we have a 4-tiered forensic hierarchy. And so we have DCF headquarters. And one of the things that recently happened with DCF headquarters, and some of that did come out of the Gaines Initiative, is that at headquarters, a forensic liaison team was actually put together. And there was a liaison assigned to each region of the state. And the purpose of that team was kind of to serve as the conduit between headquarters and DCF region, which I'll get to in just a second, and then of course our community. And then the next portion of that 4-tiered hierarchy is our DCF region. So DCF regional folks, and of course DCF is short for the Florida Department of Children and Families, they kind of work and manage the behavioral system of care within their region. And then they also work very closely with the managing entity that's assigned to cover that region. So in Florida, we have 7 managing entities. Although there are 6 regions, there are 7 managing entities. And managing entities are contracted with the Florida Department of Children and Families to deliver services, behavioral health services, that's mental health and substance abuse services, by way of contracts with community providers. And so that's going to be your 4th tier within the forensic system of care. And this is a map of how the state of Florida is broken down in its regions. And then it's also on the map, you'll see where we have the 7 managing entities outlined. I actually work for the managing entity that covers the blue area. And then it's called Big Bend now. Well, it was called Big Bend, and now it's Northwest Florida Health Network. And then you'll see the other managing entities that are outlined within the state. Our one area, Broward County, they're pretty big, and so there's only one managing entity that covers that area. All right, and then what you see here is another graphic. It really is an outline or a picture graph of how an individual, of course, travels through the system. Just as with, you've heard from the other states throughout today's presentation and during this panel, of course, individuals enter the forensic system by getting arrested. They have contact with law enforcement, they're arrested, and at some point during the judicial process or the criminal justice process, their competency is raised. I do want to note that in Florida, this system pretty much pertains to individuals who have felony charges. The forensic system of care does not really have accommodations or things written into statute that covers those individuals who have misdemeanors and then that may have been found incompetent to proceed or not guilty by reason of insanity. Generally, what happens in those cases is that they are, sometimes charges are dropped and then they are kind of put back into the community. If they're appropriate, they may be Baker Acted and then they travel the civil commitment process. In Florida, that's governed by Florida Statute 394. Or, they're entered into some type of pretrial or some type of diversionary program. And then, of course, as you see on the map, as they, once competency is raised, then, of course, there's an evaluation, and we'll get a little bit more into what that evaluation process looks like in just a few minutes. And then if it's appropriate and all the things are met, then they would be going to a state mental health treatment facility if they're not appropriate for the community. And then, of course, during that time at the hospital, they are given medications. Most of their stay is primarily about restoring them to competency. But of course, during that time, they are medicated. And so there is a small treatment component to it as far as the medication. And then on this map, you also see stars and you see light bulbs. The stars are representative of, the stars represent diversion opportunities within the system of care, and light bulbs represent time-saving opportunities within the system of care. All right, so when we're looking at the forensic system of care in Florida, it's governed under Florida Statute 916, and the statute lays out the legislative intent of the statute and how we want to work with and be able to assist this population. It lays out the difference between mental illness versus intellectual disabilities. In the state of Florida, of course, an individual can be found incompetent to proceed based on their mental illness or based on intellectual disabilities. Once an evaluation is done, in some portions of the process, it kind of starts at the beginning. Of course, the individual is arrested. They have some engagement with law enforcement, and then they are arrested. And then at some point, competency is brought into play. And depending on what the circumstances around that competency evaluation may be done by someone with APD. In Florida, that's our agency for persons with disability. That's another state agency. And if they are found, if their incompetence is based on their intellectual disability, then they actually travel through, the system under APD. It's not necessarily within our, it doesn't stay complete in the 916, although the 916 statute does kind of outline how that process should go. The 916 statute also looks at the training and appointment of experts, forensic evaluators. It looks at the competency to proceed process. And also in the state of Florida, once an individual has been found incompetent to proceed and a judge has committed them to the state hospital, in Florida, we have a 15-day window to get them committed. Like it's been mentioned during this presentation and during this summit today, of course, COVID-19 significantly impacted our ability to get individuals admitted within 15 days. But that is still a statutory requirement in the state of Florida. And so prior to COVID, we didn't really see what you would consider a traditional wait list. Individuals were either being committed to the state hospitals within 15 days, or they were being diverted to the community competency restoration programs. And then, of course, also the 916 statute outlines the conditional release process. And we'll talk a little bit more about that when we're looking at the community competency restoration system of care within the state. All right, so Florida has adapted the constitutional standard of Dusky versus United States. We look at whether the defendant has a sufficient present ability to consult with counsel with a reasonable degree of rational understanding, and whether the defendant has a rational as well as factual understanding of the pending proceedings against him or her. And of course, this is outlined a little bit further in the statute 916. And so when an evaluator is looking at an individual to determine their competency, they're looking at a couple of things. They're looking at, if they're competent, if they're going to continue, if continued competency requires treatment. Evaluators are looking at whether or not the individual is likely to be restored within a reasonable time period. Evaluators also look at, is treatment likely to restore the defendant? And can this treatment happen in the outpatient setting? Can this happen in the community? And if it is inpatient, do they meet the inpatient criteria? And so if you look down, and the criteria to be admitted to a state hospital is, again, of course, they have to have a felony. They have to be incapable of surviving alone without treatment. And the likelihood in the near future they would inflict harm on self or others. And all available treatment alternatives are inappropriate, and competence will respond to treatment. And so again, we kind of look at, so not only do they have to be found incompetent, they also have to be found to meet the criteria to go into a state hospital. And while those two things, kind of go hand in hand, they can be very separate. We've definitely had cases where a person has been deemed incompetent, but they don't necessarily meet the criteria to go into a state hospital. And in those situations, we work with our community providers. We do a lot of work with public defenders and state attorneys across the state to work on getting individuals back into the community, or getting their competency restoration taken care of in the community, or sometimes that does happen in the jail. All right, and so in Florida, we have a pretty robust, I would say we have a pretty robust community competency restoration system of care in Florida. We have had a community competency restoration system of care in Florida for many, many years. Part of our community, part of the infrastructure of our community competency restoration are 7 residential forensic treatment centers that we have throughout the state. We have one that's in Miami-Dade. It's a forensic alternative treatment center. And in 52 of our 67 counties offer jail-based competency restoration in some capacity. One of the things within our infrastructure in Florida is, through contracts that go through the managing entity and then with community providers, is that whenever an individual has been found incompetent, or at risk of being found incompetent, community behavioral health providers are then supposed to engage with these individuals in the jail. And the way that we've been able to do this is, of course, having those relationships with the jails, working with our community providers to provide so that they can build those relationships with jails, build the relationships with courts, build the relationships with forensic evaluators, even so that they can educate forensic evaluators on what services are available. We've done a lot of work in the state around forensic evaluators and talking with them and meeting with them and having multidisciplinary meetings, which includes the managing entity, the Florida Department of Children and Families, providers, sometimes jails and law enforcement, to be able to talk about what's available in the community. And I'll talk about this a little bit more in a second as well. One of the things that we did that came out of our the first year of our participation in the Gains Collaborative is that we went back to our respective areas and we looked at our forensic evaluations. We pulled forensic evaluations, we reviewed them, we looked at them based on the standards and the things that we have woven into our statutes and our rules and our policies. And then we spent some time, also talking to evaluators. And one of the chief things that we got from evaluators was that sometimes, they may find an individual that doesn't necessarily, that they feel like could maybe be restored in the community, but their lack of knowledge and not knowing what's available and not knowing that maybe a least restrictive option does exist, of course, for them at the time of evaluation, state hospital is the least restrictive option. So we've done some work to work with the evaluators to try to, educate them and have this open communication and continue those lines of communication so that they can use our providers, our managing entities as resources to be able to come to us if they have someone that they feel like may be able to be restored within the community. And then, of course, we have, there's statewide outpatient treatment and competency restoration services throughout the state. And then this is kind of a little dated, but in fiscal year 18-19, we had 786 individuals who were found incompetent to proceed on conditional release. And that means that they were getting their competency restoration services in an outpatient setting. They were not in a state hospital. They were not in a jail. All right, and so some of the strengths in our system of care is we have 3 competency restoration courts. We call them, they're also known as 916 courts. So these are courts that are dedicated to the forensic population. It's a judge that's assigned to this population and they only hear 916 cases. We have pretty good relationships with our criminal justice system, our mental health community, and we also offer in Florida substance abuse reinvestment grants. And what that is that it's monies that we, Department of Children and Families, we're able to contract out to communities. It doesn't have to be a community behavioral health provider. It can be courts, it can be jails, it can be anybody within that forensic criminal justice stakeholder cohort that can apply for these grants. The grants, of course, they're for prevention and treatment, and it can be at the adult forensic level and the juvenile forensic level. We do have a juvenile forensic incompetent to proceed not guilty by reason of insanity system of care. That system does work a little different, but we do have that built into our infrastructure. We also have what we call mobile response teams, and these are teams that are, pretty much kind of crisis intervention teams. They respond to hospitals, they respond to individuals' homes, they respond to a number of areas that's safe for them and their staff to go into. They have licensed clinicians that are part of these teams, case managers, where they can kind of assess an individual right away. And sometimes that results in a Baker Act. A lot of times that results in an individual not needing to go into a Baker Act, and which could possibly get them into the forensic system of care. They have connections and they have contacts and relationships. Most of our mobile response teams they sit with the community behavioral health providers, so they're able to get appointments in a more timely fashion, so that you can minimize the crisis, and that keeps the individual from having to go into an inpatient setting. And then we have our Florida Assertive Community Treatment teams. We call those FACT teams. And then we also have FACT teams. in this area is, it kind of serves our forensic population, and it serves our population that's not forensic. But we also do have multidisciplinary teams that are fact teams that are dedicated to the forensic population, which helps out tremendously in our community competency restoration system of care. All right, so some of the challenges that we see, I don't think that this comes as a surprise to most of us here. Dementia and TBIs is definitely a challenge that we've encountered in Florida, where we have individuals where their incompetence or their NGI status is primarily because of either dementia or traumatic brain injury. And that becomes a barrier because those are individuals that cannot be restored. When you think of what restoration looks like. Recently, we had a statute change, and some of this again came out of our, after we joined the Gaines Collaborative, we were able to go to the legislator and ask that an individual with dementia and traumatic brain injury that be exclusionary criteria for the state mental health hospitals. So if an individual's primary reason or cause for their incompetency or NGI status is because of dementia or traumatic brain injury, then that would be an individual that wouldn't go to the state hospital. Along with this challenge is because while that was kind of a win for us in the state of Florida, in some ways it has become more of a challenge because then we have this population that it's very hard to place and very hard to get some form of stability for them, because they kind of are in that gray area where they don't meet this criteria, but they don't meet this criteria. And so that's continued to be a challenge for us and something that we continue to work on. Another challenge that we've faced is forensic evaluations, some of it being no quality control, which is why after our first year participating in the Gaines, we kind of did, we reviewed lots of evaluations. We started in the Northwest region, which is the region I work in and cover. And then we were able to move that out across the state as well, so that we can try to get a hold of some of the quality control issues. We can look at if there's a true need for there to be refresher training for evaluators, because right now we do not have that. Once an evaluator goes through the 3-day training that is given by one of our colleges here in Florida, University of South Florida down in Tampa, they're not required to have any additional training to maintain their ability to be hired by the state or the courts to do the forensic evaluations. Another challenge is more intense jail-based competency restoration is not widely utilized. So a lot of what we saw definitely pre-COVID is that we had our providers that go into the jails, they meet with the individuals, they talk with the individuals. Some of them they already know because they cycled in and out of their facilities continuously, and now they've got to a point where now they have a felony and they've been found incompetent. And so trying to talk with them, build rapport. In Florida, in our jails, medication is voluntary. In some jails, in smaller rural areas, medication is kind of, in a lot of cases not an option because it's not something that jails can pay for. And that's another kind of challenge that we see when we're talking about, in the community or jail-based competency restoration. And so with COVID and with individuals, having to remain in the jail longer, and just with the creation of the forensic liaison team that was stood up here in the state of Florida and put together and kind of spearheaded by Leoville Compton, who some of you may know, we were able to really get in there and do some work with our courts and with our jails and with our community providers. And we've been able to see some shift of the pendulum so that, where there's more intense jail-based competency restoration, where they're actually getting in there and doing the competency restoration courses and everything in jail. And in a couple of our counties, we've been able to stand up some pilot programs. Some of that has been through reinvestment grant monies, where everybody who's at risk or who's been found incompetent to proceed is kind of assessed. And if they're appropriate, then they do their jail-based competency restoration in the jail. The judges actually sign orders saying that this individual has been found incompetent to proceed and they're ordered to participate in jail-based competency restoration services. And that's been a really good win for us. not just for our system of care, but really for the individuals that we're serving. And then another challenge, of course, is continued increase in commitments. And this has kind of been exacerbated by the COVID-19 pandemic. I wouldn't say that we've seen an increase in commitments, whether, our commitments look more because of some of the issues we've had because of COVID-19, getting individuals admitted and out of the jails into the hospitals or out into the community. All right, so some of the efforts that we've made to decrease commitments, one of the things that we did right away is we have this flag packet process that we do. And so in Florida, all packets are of course, rolled up to our DCF headquarters. And then we have an admissions team where they look at the packets and they review them. Part of that team is a psychologist. And so they look at the packets, and if it's a flag, we flag packets that are third-degree nonviolent felonies. So if the individual has a third-degree nonviolent felony, and after reading the packet, it looks like there may be an opportunity for diversion, what happens is that packet is sent back down to the managing entity, and then the managing entity works with the community behavioral health provider, the forensic specialists that are housed with the community providers to see if they can be diverted. Another thing that we've done, of course, is the forensic multidisciplinary teams that I spoke of a little bit ago. They follow that ACT team model, so the assertive community action teams, to be able to provide that intense level of services. And we have 5 of those teams that are out throughout the state that are dedicated to the forensic population. And then we also have the early diversion pilot project, which is something that I spoke of just a little bit ago. And some of those projects in some areas include peers. And one of the things that we do in Florida is that we are heavily vested in peers. We definitely understand and acknowledge the value of peers. And we have done a lot of work to weave peer support and peer participation into our system of care at every level, at every step. Part of the forensic liaison team that is with the Florida Department of Children and Families, our headquarters, there are 3 peers that sit on that team to be able to help navigate some of the things and be able to help us keep that peer piece in perspective. And then this is a picture actually of our original team during our first year that we joined the Gains Initiative. And in most things that we do, of course, we do a cross-community learning that includes, of course, judges, evaluators, DCF staff and leaders, law enforcement. Of course, another thing within Florida is that we have very strong crisis intervention teams throughout the state. That's another priority for the state of Florida, not just in our behavioral health, but within our law enforcement as well. And so 3 of the priority areas that we begin to really look at coming out of the Gains Initiative was we looked at improving the quality of our forensic evaluations, enhancing our mental health screenings at jail booking, and increasing our community capacity. And so some of our proposed outcomes was, look at statutory changes, where evaluators would be required to do that refresher training that I talked about, excluding the TBI and dementia in the definition of mental illness. And we were successful in getting the TBI and dementia in the excluded from the definition of mental illness. We looked at utilizing the Florida Network of Care website, which is a website that was created so that there's all the resources within the state there. Our evaluators can go there. Our attorneys, public defenders, state attorneys, judges can go there to be able to see what's available out there, and with the hopes of them utilizing that to help them kind of, get an individual to the most appropriate level of care. We conducted statewide jail screening surveys, and then we, of course, looked at increasing our jail-based competency restoration. We also looked at, of course, we conducted the forensic evaluation. We started in the Northwest region of the state, and we were able to move that across the rest of the state. And we found, we were able to find some good data out of that allows us to be able to go forth in future legislatures, and we were looking at policy and procedure in the future to be able to make some changes. We solidified regional procedures for flag packets. We provided sequential intercept mapping, technical support in areas that may not have had it, and really trying to push that across the state so that we can identify our gaps, look at our service, or build a service inventory, which of course continues to allow us to identify gaps so that we can look at ways to fill those gaps and address any other barriers that comes along with those gaps. And then we were able to establish a statewide forensic peer specialist work group, and that work group is still going strong. And one of the big things that group worked on in the state of Florida, we have a peer certification, so an individual can be certified as a peer. And one of the things that we looked at in that group was creating a curriculum so that we can have designated forensic peer certified peer specialists. And so that curriculum is almost done. It's in the final stages, and we hope to be able to get that presented to our Florida Certification Board and our higher up leadership and within Department of Children and Families, so that we can move that forward and be able to increase our forensic certified peer, our inventory and amount of individuals we have that are specialized in the forensic arena. All right, so what are our next steps? We're of course, we're continuing our one-year goals, looking at evaluations, looking at statute changes, resource development, of course, information distribution. One of the things that we definitely wholeheartedly believe is that having the knowledge and having the information about what's out there is definitely something big when you're looking at diversion and looking at getting individuals into the most appropriate level of care. And then, of course, some of our developed goals and action steps is looking at things from a state perspective, a regional perspective, and also a local perspective. All right. Thank you guys so much. I appreciate you. And I'll turn it back over to, I think, is it Linda?
Erica.
Erica, I'm sorry, Erica.
It's okay.
Hi, everyone. So thank you so much for these presentations. We are now ready to move over to the discussion group. We are going to run offer the certificate concurrently with the discussion group just to save some time because we are coming to the close of the event. So when you see the file transfer box come up on your screen, if you'd like to download the certificate, just click the file name and hit download. And now I'm going to turn it over to Dr. Callahan to begin the discussion group. And just an FYI, we will run a couple of minutes over. So if you'd like to stay on until about 4:50, we will be here.
Thank you, Erica, and thank you everyone for your presentations. I think listening to all 6 of the presentations, the state-based presentations today, it's to me really impressive the amount of work that's gone into this, the dedication, and the outcomes I think are just fantastic. And if any of you have any specific questions that you want to direct or have a longer conversation with any of the individuals representing their state teams, I'm sure they'd be more than happy to talk with you about their work or their research, etc. There's really no rhyme, no reason to the questions I'm going to ask. I think some of them are because they popped up in questions more often, but the first question I wanted to ask, and any one of you can answer this. A couple of the participants actually wanted to know a little bit more about how you can sustain housing for people who are in the competence system, especially some of the individuals have burned bridges and might have even order protections, stay away orders from particular shelters. So I wonder if any of you have any particular strategies for supporting housing with this population.
Lisa, I'll respond to that. I mean, I will admit that it is a challenge. Housing is a challenge, and I think that we can all agree with that. Definitely with the forensic population. Some of the things that we've done in Florida, in different areas across the state, is just really working on relationship building and really trying to, what we found is sometimes, when we submit like a packet or so we submit something in writing, it's kind of No. And so some of the things that we've done is really try to talk with housing providers, whether it's an ALF, whether it's a private owner and things like that, to be able to talk to the individual off the paper. Because I think we all can admit that some of our individuals look very bad on paper, but trying to go that extra step to discuss with housing providers, you know, what the individual, where the individual may look on paper and all the gains they've made, and really just getting them to see them off of the paper.
Thank you, Tracy. I heard that also from the Nebraska presenters of how important developing those relationships are with people out in the field in terms of working with the forensic population. And I think the way you put it, Tracy, that sometimes they don't look so good on paper, but when you can have a conversation, that you probably have more leverage. Another question that came up, and I know this was addressed a little bit around compelling treatment. That if people are, how do you compel someone to take medications or other treatments if it's part of the court order? And I'd like to ask Dr. Candelas from Washington, D.C. to perhaps respond to that.
Yeah, I mean, there are some important distinctions in coercing treatment, especially for the purpose of competence restoration. So DC doesn't permit it technically. There's no outpatient involuntary medication statute. Chad can correct me if I'm wrong, but the difficulty is where the leverage comes from. So Dr. Tilbrook did mention that there is a requirement that you follow the treatment requirements of the Department of Behavioral Health, but then how rigorous are the enforcement mechanisms? And our outpatient mechanisms are not that tight. So, Chad, am I saying that correctly?
Yes, that's correct, Phil. I think, and just reading some of the discussions here in the Q&A, that's a challenge you're going to find in any community-based programming. Is what's the stick, what's the carrot, and where's that leverage coming from? Sometimes it does come from a very social work-minded, proactive judge who has a significant investment in this population and is tired of seeing these folks come across their bench week after week. Others have a very active defense attorney who wants to help them. If you're able to engage an ACT team or a community-based support team to help ensure treatment adherence, then you're in a better situation than those that don't have that. But as Phil mentioned, we don't have any outpatient medication statutes in DC that to force medications or to prescribe it involuntarily.
Anyone else want to weigh in on that from the other presenters or Dr. Pinels?
I'll just weigh in and say engagement. That's what we really need to do. And, there can be, since they're pretrial, there can be conditions of release and all these things that can be put in place. But really where we want to get to is trying to understand what are the barriers for that person taking their medications, because we got to think long haul that these are people we really want to have in treatment. And it's easier said than done, of course, but supports and engagement are really the strategy.
Thank you, everyone. There were a couple of presenters who talked about a curricula that were being developed, one for the peer support specialists in Florida. And Chad, I think you mentioned that you've revised your training curriculum a couple of times, and that was also the restoration curriculum, and that you modified a couple of times. I wonder if you would be able to share those with us, and perhaps we could make those available on our microsite for people who would want to look at at the curriculum that you've developed, whether, maybe what your second or third version of it is, the one that you're working with right now.
We took advantage of the time during the pandemic, so yes. I'll be happy to share that with you all.
Okay, thank you. And we'll put that on our microsite so that those resources that have been mentioned will all be housed there so people can access them. Let's see, any other questions that, I'm going to ask this question. Someone asked why in Florida you limit restoration to people who are charged with felonies versus people charged with misdemeanor and felonies. And Tracy, I'll direct that to you, but I also want to note that that was probably in the very beginning of the learning community almost 4 years ago now. That was probably one of the major goals of many of the states, was to somehow reduce the number of misdemeanors for which you're having evaluations and we're providing services to through the forensic system and not through the community-based system.
And so what we found is of course, with a lot of the misdemeanor charges, they're low-level offenses. They're they're trespassing. They're things that could be, and that could be addressed in the community. We also found that if we look at like what would be this individual's sentence if they with the misdemeanor, some of it is individuals just being released on their own recognizances, or maybe they get 30 days, and sometimes it takes that long for an evaluation to occur, and so they're sitting in jail longer than they need to be sitting there, definitely on a misdemeanor charge. To try to address that part of our system of those individuals, that population, is we try to do more prevention things and work with that population from a prevention standpoint. I would just say another reason being that I think we all can agree that in states where there are state hospitals, beds are limited. And so if there are ways that we can kind of prevent and divert portions of that population, then we try to do that. And we kind of see that our misdemeanor population is more of low-hanging fruit for that to be done than those individuals committing felonies.
Thank you, Tracy. I also want to draw everyone's attention to the response from California about some of the incentives they use in Los Angeles. The carrot part, Chad, that you referred to in terms of using outings and visits with families, et cetera, as some of the incentives they use for complying with the recommended treatments. Any other questions or any other last words? We're over the time, which I'm so grateful that everyone so many people stayed with us for the full 5 hours. That's a lot of time to be talking about this, but I think as everyone can see, there still is a lot left on the table. As I mentioned at the outset, we are going to continue the community of practice with the states that we're already engaged with, and the topics that we are going to drill down on, I heard actually mentioned a lot today, and it's on risk assessment within the context of restoration, so that knowing how we can meet this public safety concerns, but also the best clinical setting for people who are in the competence process. And part of that is not just talking about the tools of risk assessment, but also talking about how to have the conversation with the justice professionals, what risk means. As Judge Waller said, judges and behavioral health people have different views on what risk is. And so we're going to have part of the community practice is going to be on talking about how do you talk about risk and what does it mean in this context, and how can you incorporate it into finding the best setting for someone if you do have different settings available for people for restoration. I think, as you can tell too, many of our states have made great progress on not just the aspiration of establishing community-based restoration, but also really reaching the reality of that. And I really want to applaud them, because it is a heavy lift, and really am impressed that they've been able to do that work. Dr. Pinels, do you have any last words before we sign off?
I just want to thank everybody for all their innovations. As many times as I go to these conversations, I learn new strategies myself, and it's through the hard work of everybody here. And just really want to appreciate, send out an appreciation to the Gain Center, to Lisa, to the team at PRA, and to the SAMHSA partners for putting this together.
Thank you. And I will now pass the baton to Erica to close out with a few housekeeping slides.
Thank you. So next slide, please. When you receive your copy of the slides, you'll be able to click this link where you can access the Competence to Stand trial microsite that Dr. Callahan just referred to. And your certificate of attendance will make that available one last time via file transfer. Here's the information where you can sign up to receive our e-news from the Gain Center. And our contact information is here. If you have any other need to contact us in the future, we'd love to hear from you. And thanks so much, everyone, for joining us today.